Welcome, everyone. This is the final session of the July 2024 bar exam season. For me, I have a few tutoring sessions left before the exam, but this is my last class, except Safwan and CJ and one other student stick around because I want to do a recording of the California questionnaires today too. So this is my second to last recording of the bar prep season. It's been an amazing experience. We have these feedback forms in the classroom that I hope you take the time to fill out. And if you're going to mention anyone in particular, I'd appreciate you mention your customer service representatives. You know, they go above and beyond, and that's something I take pride in, is not just giving you all materials and resources and exposure to me and my tutors, but also having a one-on-one concierge to help you navigate. So we work hard behind the scenes, and we appreciate the positive feedback or the honest feedback if that's what you would like to give. So we are going to work on the master cram guides today. And the master cram guides, as you know, is a combination of the cram guides I've made for the past 3 administrations using the students in the class. They picked the answers, got them mostly right, and then I've documented what we've learned. We've already gone through contracts. We've had the great fortune of going through torts. We were so blessed to get through constitutional law and even had the divine luxury of reading all the real property ones. So that leads us into the most exciting subject on the bar exam, which is civil procedure. So I'm going to talk about these things as I read them. Let's stay locked in. What did I play to start class, Erica? The graduation song? Yeah, let's just know that we'll be friends forever as we go on life together. And just do your best on the exam. It's just a test. We're too blessed to be stressed. And civil procedure is a subject that my students are going to excel in. Why? Because they're listening to this lecture right now. Okay. A denial to a complaint is appropriate in answer if it is made in good faith and belief that a denial is warranted. For example, if a company president has good reason to believe an employee was fired for incompetence, she could deny an allegation of gender-based firing, right? So we have the complaint, and then in the answer, you're allowed to include a denial and say, this isn't why, right? You wouldn't necessarily implead a third party and say, you know, they're to blame unless you're filing a claim. Remember, an impleader is a third party claim. You actually have to file a claim against them, where this is just a mere denial. A class action seeking only injunctive relief does not require notice for all of the parties to be bound. Notice is required in common law question class action lawsuits. So Safwan and I were actually discussing this, I think yesterday or today, and he remembered that Carolina was the student who read this while I took one of my snack breaks, and we're going over it again. And we talked about it in class this administration. Now I'll talk about it for the third time, right? We'll all understand this exact point, that a class action claim seeking only injunctive relief does not require notice for all the parties to be bound, right? There'll just be notice implied. Angie, I remember from class this administration, was a student who got this one right. Notice is required in common question class action lawsuits, but it's not required if it's only requesting injunctive relief. Spoliation of evidence is a sanctionable offense, and as long as there's not an abuse of discretion, the decision will not be overturned to dismiss the case, for example. So spoliation of evidence, allowing evidence to spoil or not be usable anymore, is sanctionable. But so long as it's not an abuse of discretion, the decision will not be overturned. Because remember, an abuse of discretion will constitute a plain error that would warrant being overturned. If you see that answer, it's a plain error that constitutes an abuse of discretion, then, you know, maybe we could look into it. Abuse of discretion is going to be about letting evidence in or not letting evidence in, or, you know, decisions that they made that could have affected the case. If a motion for a new trial is granted, there cannot be an appeal because there's no jurisdiction for the appeal. Appeals are for final judgments with some exceptions, but an appeal is not proper after a new trial has been granted. They test this a lot, the final judgment rule, meaning we do not grant appeals unless there's been a final judgment. And if they've granted a new trial, even if there was a decision, Tommy versus Johnny, Tommy wins, then Johnny moves for a new trial and it's granted. Well, that grant of a new trial means there has not been a final judgment anymore. So therefore, you can't appeal the award of a new trial. There are some things that are subject to interlocutory appeal, let's say, that are not subject to the final judgment rule. That would be like an injunction or denial of an injunction or certification of a class action or something that's just so important that they have to decide it now, because if they wait too long for an appeal, it'll lose its reasoning for being appealed. So we call that the collateral order doctrine, or extraordinary writs would be something very rarely tested. But there's narrow exceptions where you can have interlocutory review, but usually you need to wait until there's been a final judgment to have review. If an insurance company sends out a photographer to take pictures of a fire scene in anticipation of litigation, those photos are protected unless the other party successfully obtains a court order to compel, right? Because if you think about it, why would they have taken those photos if it says in the fact pattern that they were in anticipation of litigation? If they were taken in anticipation of litigation, then they're protected, right? Photographs are usually admissible of a scene, but if it says in the fact pattern that these photographs were taken in anticipation of litigation, then they're not going to be discoverable. So a judgment on the pleadings is premature if there has not yet been an answer to all claims and counterclaims. So let's make sure we understand that. A judgment on the pleadings means that we have resolved the pleadings. There's been a claim, let's say a complaint and an answer. Okay, cool. We have a judgment on the pleadings, unless there's been a counterclaim. Well, if there's been a counterclaim, there needs to be an answer to that counterclaim to really say that there has been a finality of the pleadings and therefore be appropriate for a judgment on the pleadings. So it's premature. There's not been an answer to all claims and counterclaims. Dismissal is not the proper remedy for misjoinder because severance is, right? Look out for that answer. It'll be like A, you'll think, oh, we should do dismissal because they're misjoined. And then D will say they should be severed. D is going to be the better answer. Parties may stipulate to a jury of less than 6 in rare circumstances, such as when all alternates are exhausted. So in civil litigation, you can have a jury of less than 6, right, if the parties agree to it in rare circumstances. Furthermore, they may stipulate to a non-unanimous jury. So in civil litigation, there is flexibility for the parties to stipulate to less than 6 or to non-unanimous jury decisions. A party may not use an affidavit to raise a genuine dispute of material fact in support of summary judgment if it did not disclose this affidavit as required in earlier discovery. I remember Zach helped us get this answer right in the class this year. Really tough question, but the question was saying that, like, you know, Tommy is well, let's use a different example. Let's use the Jack Russell on my lap. Say Biscuit. I know it came out of nowhere, right? Biscuit is involved in litigation against Rosie, right? And they go through discovery. And then after discovery, we've already, you know, closed discovery. Now Biscuit's trying to move for summary judgment. Well, that's appropriate because after discovery, you move for summary judgment. But why is he moving for summary judgment? By creating a dispute based on some affidavit that was not already disclosed in discovery. Like, that's the point of summary judgment. It's based on all the things you disclose. Now there's no dispute of material fact. You can't just bring an affidavit from outside the scene. So even though Biscuit has listened to a lot of lectures over the years, he's been through every single one for 7 years now, he still could not bring that affidavit from outside the scope to create a genuine dispute of material fact. Okay, so if a party seeks 200K and is awarded only 1,000, it would likely succeed in a motion for new trial based on inadequate damages, but probably wouldn't succeed in a motion for JMOL. It definitely would not succeed in a motion for JMOL because the verdict was already in its favor, right? So these are some post-verdict motions. Like, let's say we have a renewed JMOL. Well, if it's Rosie versus Biscuit and Rosie prevails, and now Rosie moves for a JMOL, that would make no sense because Rosie prevailed. But if it's Rosie versus Biscuit and Rosie prevails and she only gets 1,000 and she was entitled to 75,000, well, that would be reason for a new trial because we'd have to, you know, reassess the damage allocation. But the verdict wouldn't need to be assessed. It's the damage allocation, which would be the reason for a new trial. So the right to a jury trial in the Seventh Amendment for legal relief for suits that were actionable at common law, the right to a trial before 1791. Therefore, if the fact pattern states that at common law, a certain offense was not suable, there's no modern right to a jury trial. It's tough questions on this. So let's talk about the Seventh Amendment, right? Basically, we'll talk about the Seventh Amendment, your favorite one. So under the Seventh Amendment, there's a right to a jury trial for cases at law, meaning monetary relief over $20. If you're suing for less than $20, you're fucking crazy, right? You're like some of my students who just want to peck at things. So you wouldn't get a jury trial for that $18 case, let's say at federal law, but you do have a right to legal relief jury trials at federal law, not for state cases unless the state grants that, right? So there wouldn't be a jury trial for equitable relief. Now, if there's a case where there's equitable relief and legal relief, and you get a jury trial for the legal relief, they always do the jury trial before the regular trial, even if the jury trial was like amended and came up later, like that matter. Here, when they're talking about, yes, it's for legal relief, but it's also for cases that were actionable at common law. You had a right to trial before 1791, like writs of ejectment. I know there's some smarty pants out there that can remember another one off the top of their head that was actionable before 1791.
I think Replevin's the other one.
And replevin, nice. Acts of ejectment and replevin were cognizable by trial before 1791. The question is going to be in the fact pattern, they'll probably tell you, like, you could not sue under this act before 1791, and you weren't entitled to a jury trial. That would be the reason why. So there's also another tricky thing that they test, which is like, well, at least it tricks me, which is like, here's a statute that says that defendants may request jury trials, and then the plaintiff requests a jury trial. And I want to pick the answer yes, because the statute authorizes jury trials in this instance. But the answer is no, because it authorizes it for the defendant, and the plaintiff was the one who was seeking it. So they're really, it's not the nicest test on earth if you haven't gotten that understanding by now. But it's also very passable, extremely passable. And Judy, you're definitely passing. So if duress is a complete defense to breach of contract and a party presents uncontradicted evidence of duress, summary judgment should be granted, right? That's a fact pattern where they're like, in this jurisdiction, duress is a complete defense to summary judgment. And if it is if they show uncontradicted evidence of duress, then they have to grant summary judgment. A lot of these questions, real property and civil procedure, the hardest subjects, the reason people do the worst on them is not because the material is so necessarily hard, even though that is very much part of it. It's because the questions require careful reading and analysis and comprehension skills. So just remember that. Just read carefully and be like, well, this question said duress is a complete defense. Well, should it be granted? Yeah, of course. So if we have a man versus neighbor and there's avowed easement judgment, and then we have a buyer versus neighbor and there's privity. Why? Because there's different parties. But for issue preclusion, a subsequent landowner is a privy for the purpose of issue preclusion. Does anyone remember what I say is the common example of privity for claim preclusion on the MBE? If none of you know, I get to take a bite of my acai bowl with the bananas and the strawberries.
Would it be like an employer or like a business partner?
You could have given me like 2 more minutes to swallow my food, but yeah.
No, I saw you enjoying it, so I just want to,
Yeah, I know. You watched the fights last night, obviously, the UFC fights?
Tom Aspinall round 1 was a great prescient little estimate, little guess. Yeah, watched the whole thing.
What do you think about Patty the Batty?
I'm a jiu-jitsu guy, so I thought it was awesome.
He's kind of funny though. He's got like a good personality, I feel like. And a good nickname. Yeah. You're the Restitution, right?
Yeah, that's me.
That's you, Mr. Institution himself. I posted all the album covers on my Instagram, so if anyone follows me, you can see all the albums that were submitted. It's pretty good stuff. Hey Zach, do you mind taking over like 3 points while I take a few bites and explaining anything from the class that they need to know, just like from here to here?
Yeah, sure. All right, so we have failure to raise a judgment as a matter of law, precluding the ability for the appellate court to consider it for the first time. The takeaway is that a party has to raise that initial JMO to bring a renewed later. There is no renewed without the initial. Next up, we're gonna talk about motion to dismiss for personal jurisdiction, venue, service, process of service. These must be brought in first response or else they're waived. Remember that 12B6 omnibus rule. If you're looking for charts, like under UWorld, it'll be under that kind of tagline. Supplemental jurisdiction allows a co-defendant to bring in another party, even if that party is not diverse. The impleader must bring in an issue that arises from the same common nucleus of operative fact. It's important to note that plaintiffs cannot bring in a third party in a federal diversity case if it would destroy diversity. However, it is okay for a defendant to do so.
Can you explain everything you know about supplemental jurisdiction to the class?
Yeah, so if we're going to talk about supplemental jurisdiction, there's kind of two main like avenues that I think of. One would be aggregating claims together against a single defendant. In terms of adding those claims, there's different types of permissive and mandatory claims, counterclaims as such when you bring in a party. But the main rule for the aggregation is that the party can bring in those claims so long as it's over that $75,000 threshold. Another way that you're going to kind of seek the supplemental jurisdiction is out of federal question jurisdiction. Now, you're not going to be able to obtain supplemental jurisdiction under federal question if the party, let's say the defendant, is raising a federal defense. The defense to a federal question or federal law is not going to raise the stakes to meet that federal question for supplemental jurisdiction purposes. But honestly, I think this last line, it's important to note the plaintiffs cannot bring in the third party in a federal diversity case if it would destroy diversity. I'm going to try to commit this to memory, tattoo this onto my brain. I think it's super important. I think that's like that one line. If you guys are going through like these Civ Pro questions, they're really thick. There might be that one line where it's let's say it's the plaintiff bringing in, and it's destroying diversity.
Rafik, you did amazing. I was gonna say, did you watch the main fight though last night? Obviously.
Yeah.
And now they need to rematch for the third time.
No, I think Shavkat's gonna get a shot. I think Dana and Hunter probably called up Shavkat like immediately. They do not want to see that again. Yeah.
Interesting. Cool, man. Well, it's always good. I know that you got the fighter in you. You did really good. It sounds like you might need a glass of water, man. Your throat was kind of getting a little dry at the end, but you did a really good job of explaining these three things. Failure to raise JMOL, you gotta bring it or you're gonna lose it, right? 4-year-old virgin. If you don't use it, you lose it. I didn't mean to say that right after you did. I'm just kidding. We're not 4-year-old virgin. Motion dismissed for PJ venue service. Process of service must be brought in the first response or else waived. That one, it's got to be brought in the answer or the pre-answer motion or whatever, the first opportunity. Now, if you bring it in the answer, if you don't bring in the answer, but then you bring it in the amended answer, that's okay. You're allowed to do that because it's amended answer. It relates back. And then everything you said about supplemental jurisdiction was amazing. That it's okay if the defendant brings it in and it destroys diversity. That's okay, as long as it arises from the same common nucleus of operative fact. These terms, same common nucleus of operative fact and same transaction or occurrence tend to mean pretty much the exact same thing, and they're used in a lot of circumstances on the test. Okay. Non-mutual defensive issue preclusion is when defendant who is a non-party seeks to preclude an issue from being litigated. However, the party which they are using issue preclusion against must have had their day in court on the issue, have been a party in the previous lawsuit. So again, non-mutual issue preclusion. That's the concept of using issue preclusion when the party that you're using it against was not a party to the original lawsuit, right? Like usually when we use preclusion, it's the same parties in the same configuration. A versus B, we litigate something and now A versus B are trying to use it again, or B versus, A versus B is trying to use it again and we're going to be precluded from using it. That's going to be mutual preclusion. For claim preclusion, it always has to be mutual unless, like I said, it's a privy like an employer-employee. For issue preclusion, it usually needs to be mutual unless it's a privy like a land owner and a subsequent buyer, but it can be non-mutual if the jurisdiction allows for it. And if the jurisdiction allows for it, then they still need to have been a party in the previous lawsuit, you know, to have had their issue in court, meaning that they had to have somehow defended it in some manner for it to be used against them. It can't just be used against them if they were never able to speak about it. So tough concept there that's coming from a particular question. What I'd like everyone to just take away is issue preclusion versus claim preclusion. Claim preclusion is the entire case. Issue preclusion is more narrow and has to have been actually litigated. And on the test, they'd like to see if it's been actually litigated by telling you it was pursuant to a general verdict or it was dismissed. If that's the case, then it wasn't actually litigated and issue preclusion wouldn't apply. A party may not seek discovery from any source until the parties have conferred for their initial conference. So, right, you can't do discovery until the initial conference. And then once you have the final pre-trial conference order, you're not going to amend it unless there's been a showing of manifest injustice. If you are purposely in a state, not judicial or other involuntary reason, you can be served, right? That's tag jurisdiction, like tag you're it. They hit you with service and now you are availed yourself to being served. Transfer of venue is procedural under Erie. Remember, if it's procedural, it's governed by federal procedural law. Erie applies to diversity cases, and you're going to apply the state law of the court in which the state in which the federal court is sitting for substantive issues, and you're going to apply that state's choice of law under Claxon for substantive issues. But for all procedural issues, you're going to apply federal law, and transfer venue is a federal issue, a procedural issue. If it's a federal question claim, like it's not diversity, you're not going to apply Erie at all. You'll just apply federal substantive and procedural law. That's a tough thing to like to test. A motion for judgment on the pleadings can be made after the answer. However, if there's a counterclaim, the motion cannot be made until there's been answered the counterclaim. All right, we repeated that one. You all better get that right on test day. I pray, right? A civil jury must begin with no more than 12 and at least 6 jurors. So no more than 12 and at least 6. If there are less than 6 jurors left, a mistrial must be granted unless the parties stipulate to a jury of less than 6. And like we said earlier, parties may consent to a jury of less than 6 jurors. Forum non-convenes is a doctrine that allows a defendant to dismiss a case and have it refiled in a more convenient venue. It's not a motion to transfer, it's a motion to dismiss. The court has discretion and the petitioning party has the burden to show hardship. So that's a key thing they like to test is that, and I keep saying that they like to test. Like, I don't know if they like it, they hate it, they just test it. Sometimes they say they love to test it. That's a key thing that they test is that forum non-convenes leads to a dismissal and a refiling, whereas transfer, a motion to transfer would lead to, transferring to a venue that was originally proper in the first place. Forum non-convenes is actually a dismissal and refiling. Most issues in a case are not reviewable until there's been a final decision, this final judgment rule. Some issues are potentially subject to interlocutory review, and I said this earlier, including the collateral order doctrine, which arises when there's an issue that has been conclusively determined by the lower court. It's collateral, separate to the main issues of the case, and will be unreviewable on appeal. Those are the standards for the collateral order doctrine. The standard for amending a final pretrial order is to prevent manifest injustice. And I told my class earlier that all the album covers are on my Instagram story right now, if you really want to see them. But one of my students, I always think of him, EJ, for manifest injustice. That was his rapper name. And that's to amend the final pretrial order. He never actually made the album cover. He's too busy representing NFL players. Hey, stop that. Thanks. If a party has the burden of proof of showing someone is deceased, they must show evidence they are dead, not just missing. I always refer back to this, like the Tiger King thing, or the fact that like the husband's probably not dead. The husband is probably in Tijuana with a wife half his age or a new girl half his age, and he faked his death. That's what we have to assume on the bar, right? And then the woman too. The woman's not dead. The woman has ran off with the pool boy and they're, swimming in Canada right now or something. Or where does everyone go? In Greece. They went off to Greece, right? And they faked the death. That's what you have to assume. So show me the body. We can't assume that they're dead. We have to show them. So that presumption is great. Okay. A federal court may grant a new trial on its own for any reason a party may have been granted a new trial. So federal courts can choose to grant a new trial even without a party requesting it. When a trial reduces the amount of punitive damages awarded, the decision is renewed de novo by the appellate court. So remember, adder in federal court is not allowable, and reduction would be reviewed de novo. And if they do grant a reduction, they also have to grant the alternative of a new trial. A party can move for a JMOL after the other parties present evidence, but before a verdict has been rendered. After the verdict, so long as the party has raised an initial JMOL, they have 28 days to raise a new JMOL. Affidavits may be provided early on in the litigation process, including pre-answer motions. The difference between motion for summary judgment and a motion to dismiss for failure to state a claim is failure to state a claim is that a claim isn't plausible, assuming all the facts were true, where summary judgment can introduce affidavits, evidence, etc., to dispute genuine issues of material fact. Right? So summary judgment is no genuine dispute of material fact, and failure to state a claim means you have a claim. I mean, you don't even have a you don't even have a claim. Like, no, summary judgment means you have a claim, it's just not going to win. Failure to state a claim means like you don't even have a claim. You're trying to sue Andrew for being like ugly. Like, that's not my, I mean, I don't know if it's my fault. Maybe I could have like done more things to prevent that. But the issue is there's no claim for being ugly. It's not actionable, right? That would be a failure to state a claim. If you said failure to perform the contract, and I'm like, summary judgment, I've literally been up here for 3 months straight, every single day, 52 classes straight, like 500 hours of tutoring straight. Like, I definitely substantially performed my contract. Here's all the receipts. That would be no genuine dispute of material fact, summary judgment. You had a claim that I didn't perform. I proved I performed, summary judgment. The earlier one, you had a claim that I was ugly. That's just failure to state a claim for which relief could be granted. Because even if you proved it, and it would be, I guess, easy to prove, depending, according to my brothers, right? Then it would be easy to prove, but even if you proved it, you would not be awarded any damages. There's no actionable claim. That's failure to state a claim. I feel like you'll never forget that. Failure to state a claim is like stating that someone's ugly. Okay, so you should file an answer before a motion for summary judgment or anything else that's not 12B, right? Yeah, you should definitely file answers before then. If a case is dismissed with prejudice, it is then barred by claim preclusion. So dismissal by prejudice one time, you can't bring it again the second time. For claim preclusion to apply, it must be the same parties or the privies in the same configuration. What that means, if it's A versus B, then B versus A's privies could be issue preclusion, but not claim preclusion. Issue preclusion can be a different configuration. Claim preclusion needs to be the same configuration. That's kind of the difference earlier about when you can apply issue preclusion, and it's it still needs to be usually mutual. It's still mutual, but it's more flexible because it could be a different configuration, right? A versus B versus B versus A. So the parties may stipulate to less than 6 jurors in a civil trial. They must start with 6, not more than 12 in a civil jury. We said that 3 times now. You better get that one right. A court may grant an untimely jury trial motion, and the other party does not have to consent. When there's improper venue, you can either move to dismiss or move to transfer to a proper venue, but it must be to a venue that was originally proper to file. You cannot force another party to make disclosures before they have the opportunity to make supplemental disclosures. For instance, if it's 6 months before trial, you cannot compel discovery of which expert witnesses will be called because the other party has time to disclose. Erie analysis. So this applies to diversity cases, not to federal question cases. You apply the state law of the federal court in which they're sitting for substantive issues, and damages are considered substantive. You have 21 days to respond to a complaint in federal court. At a bench trial, the judge must provide findings and conclusions with judgment. So juries do not need to do this with verdicts. but a judge has to do this with a judgment. It has to do findings and conclusions. Give me 1 second. I get the most spoiled dog back in the mix. If he's not on camera, he's crying. I know. You're a star. He's like, I'm a star, man. Put me on the camera. At a bench trial, the judge must provide findings, conclusions, and judgments. Juries do not need to do this with verdicts. Ordering a party to submit to a physical or mental examination is a procedural issue, and thus federal law applies. That's another federal, issue, procedural under Erie would be whether or not a party has to submit to a physical or mental examination. Remember, procedural issues, the order of the witnesses, how many days you have to respond to things, like things that are procedural that aren't really substantive. Relation back applies to correct a mistake in the named party, but not a strategic choice not to sue the party originally. They test that, like it has to have been a mistake in the party, like you wrote the wrong name, but not like a strategic choice, like you didn't want to sue them and now you're trying to sue them. That's relation back. Tough question. Allegations without support are not enough to defeat a motion for summary judgment. The better response is you need more time to determine additional information. That's an answer that I see as a common answer. You need more time to do discovery. You need more time for additional information. All right, Justina, what you got for me?
On your last point, when you didn't sue the other defendant to start the case, for clarity, it would be you chose not to add or sue defendant 2 for a reason, whatever it is. The statute of limitations runs. Then you change your mind, you're like, I do want to sue that person. Relation back would be unavailable.
Exactly, because you could have included them in the original complaint, but for whatever reason you didn't, you chose not to. Now, it could be available if you misspelled their name or something, and now you want to, correct that to be the right party. Okay, so someone's entering the room. Who is it? Should I let them in? Oh, definitely. I was wondering where she was. Is Alessandra here? Hey, Vanessa, what's up? Welcome. Is Alessandra here too, or you two are locked in?
Probably not. She's already driving, and I just started driving to
All right.
Tampa, so
Bet this is going to be a good thing to listen to while you're driving. We're talking about
exactly.
the procedure, but I was looking for you and Alessandra, but I'm happy you're here. Rosie's with me right now. Biscuit's crying. Okay, so we're talking about the standard for JMOL. It's whether a reasonable jury could find or could not find for the non-moving party. So that's JMOL. So remember, summary judgment is there's no genuine disputed material fact, but for JMOL, it's whether a reasonable juror could or could not find for the non-moving party. So you'll always, when these motions are made, JMOL or summary judgment, take all the facts in the light most favorable to the non-moving party and then apply the standard. So again, the standard for summary judgment is no genuine disputed material fact. The standard for amending a final pretrial order, again, is to prevent manifest injustice. That was EJ's rapper's name. Rule 11 prevents an attorney from filing a frivolous claim. So definitely can't do that. And if you find out after you file that, Supreme Court ruling has come out that makes your claim frivolous, then you do have a duty to retract it. You can't continue to pursue a claim that has become frivolous in light of recent precedent. If the demand for a jury must be made 14 days from the answer. If no answer is made, you can make an amended complaint demanding a jury. So demand for a jury must be made 14 days from the answer. But if no answer is made, then you can make an amended complaint demanding a jury. If the court determines that the jury decision does not align with the responses to the interrogatories, then the court has discretion to either rule for the other party or order a new trial. But it doesn't have to order a new trial. It has discretion on what to do. So, when in doubt, may versus must, lean towards may, unless it is one of these things like it's a must, like there are certainly scenarios. You have no rights to a jury trial for claims that demand equitable relief, specific performance, injunction, etc. And you do have a right for a jury trial in federal cases for monetary relief under the 7th Amendment, and also some cause of action such as writ of ejectment, or as Safwan told us, replevin claims, if it was cognizable by jury before 1792, what was it, 1791? 1791. That's what I said. Okay. So, we're almost done Civ Pro. Amazing. I've been waiting to be done with this subject. Pleading requirements are federal, so notice filing must show that a claim is possible, not merely plausible. A claim that Tommy drove negligently will not satisfy pleading requirements. You have to show more than that to satisfy the pleading requirements of federal standards. SMJ, fair to state a claim and fair to join a party, can be brought at any time, right? So this is a 12B defenses, whereas PJ, venue, process, and service of process must be brought the first opportunity. Remember, that's usually the answer, but if you file a pre-answer motion, it needs to be brought then. And the one kind of nuance is that if you don't bring in your answer, and you should have, but you amend your answer and then you bring it, that's going to be fine, and you wouldn't have waived it. They really test that SMJ can be brought at any time. So a denial of summary judgment is typically not immediately available. It may be appealed after decision on the merits. Of all the things that they like to test, and again, I keep saying they like to test, of all the things that they test frequently that they try to trick you and make you believe are subject to interlocutory review, this is the one I've seen the most, a denial of summary judgment. It's Rosie versus Biscuit. Rosie moves for summary judgment, it's denied, and then Rosie moves for immediate appeal. We're not going to grant that because it would have to wait until there's a final judgment. So we've really talked about the final judgment rule a lot. And we remember interlocutory review is only available for denial or maybe acceptance of an injunction, certification of a class action, collateral order rule, or extraordinary writs. Usually the correct answer is going to be no, of appeal is not yet available. We have to wait until final review. And we also saw the fact pattern today where, well, I listed the fact pattern today where if they award a new trial, then there's no jurisdiction for awarding an appeal because the new trial effectively restarts the case. There hasn't been a final judgment and there's no basis for appeal. So a judgment on the pleadings is made after the pleadings are closed, complaint and answer, but there's a counterclaim. There must be an answer before judgment on the pleadings can be raised. Again, that's the third time we did that. If we've done one 3 times, it's because these are the cram guides of 3 classes, and that's really good. Repetition and reinforcement is what leads to success on this test. Success on this test. All right, now I'm going to do something that I'm always scared to do, which is go into the chat room. 22 chats. Okay, so by the way, Vanessa, when everyone came in and Brittany and anyone else, when they came in, I told you, Brittany, you're going to pass. Vanessa, you're going to pass. I'm really professing positive vibes to everyone. I'm really confident in everyone. This is definitely my best class ever. This has been my most peaceful class, my smartest class, my most good looking class, my most amazing class. All right, so let's see. Zach said complimentary crock pot underneath each examinee's seat. Kylie is flying in at 7:30 at night, so she's launching herself into vacation mode. Immediately know she's passed. She's going to Texas. Nice. Everything's bigger in Texas. Okay. Angie's listening to Civ Pro. Biscuit is delicious. We know this. Pomp and circumstance. Acai Factor Bowl. If amending a pleading, it's still the first time they raised PJ. They did not waive it, right? We said that amending, you're allowed to bring it up. Good job, Hannah. Think about it. The plaintiff is already doing all the work bringing the case to litigate, so they can't bring a new party in to destroy diversity. If the defendant brings someone that destroys diversity, it doesn't matter. That's for supplemental jurisdiction. Good job, Hannah. Hannah said that interrogatories can be given, only be given after final pretrial conference date. Yeah, after the date is set. Yeah, exactly. Not mandatory presumptions, no mandatory presumptions in criminal court, right? Like you can't presume someone's dead, even if they've been missing for 18 years. We gotta bring me the body. Can you appeal if it's dismissed with prejudice? Yes, because it's final, right? If it's been dismissed, you can appeal. It's been a final judgment. Dismissed with prejudice means they cannot bring it back up. Final judgment, guilty face. You know, Biscuit's being good right now, super good. Biscuit and Rosie are being actually literally perfect. So newer should have known standard. What does that apply to, Zach? I'm not really sure.
Amending pleading, like if you had an idea that you would have been hailed into court.
Mm-hmm. JML, look at all the evidence most favorable to the other party and see if you could possibly find for them, like language is also legally sufficient evidence, right? They also use that for JML. What's in Tampa, Rob?
I think the bar.
Yeah, American Social. It's right next to the convention center. It's the one on the water. And the reason I'm
Perfect.
going there is because that's where my alma mater goes, and they don't advertise it because they don't think it's appropriate to advertise drinking alcohol and networking in to law students. And my retort is, these people are 26 years old. They just took the fucking bar exam. We're gonna cheers, you know. So I'm gonna see the people at UM and they're gonna be like, I don't know, maybe jealous. I don't know. I'm not petty. I'm petty as fuck. Okay, so the next one is, which claim do they do first? The jury one or the equitable one? They're always gonna do the jury claim first. Good job, Step One. Think of concepts as a string of words. Seventh Amendment, federal monetary damages. Okay, perfect. That's what I remembered. Zach saying legal, jury, or tribal claims. Hannah saying denial summary judgment is not immediately appealable because the case continues on. There's no final judgment. Rob saying drink up. Elizabeth saying when are you going? Erica's saying that is legitimately how many cases are resolved at a bar over a drink. Most business done is the bar, the golf course, period. All right, cool. Well, I play golf. I'm going to a golf tournament in August in New York. I play in this golf tournament every August, and I usually don't play any golf all year. And then after the bar is done, I start practicing. So August, I'd like to practice some golf if anyone wants to swing the old iron. All right, that was pretty good. I think civil procedure went pretty good. Here we go. Sean, notice we didn't cover removal and remand. Here we go, Sean, let's go. Remember, removal is only for the defendant, right? Only defendants can remove. If the defendant is not a citizen of the forum state, plaintiff cannot remove, but can remand if applicable, right? So forum state defendant, right? If you're a forum state defendant sitting in diversity, then you cannot remove. You could remove always for a federal question. That's a little caveat to that. But if it's for diversity and you're a forum state defendant, that is true. You cannot remove, and only defendants can remove, and defendant cannot do cross removal either, meaning, right, you can't remove sitting in Texas and try to remove to federal court in Florida. All right, little know-it-alls.
Wait, when you mean you could always remove with federal, it's still the defendant can only remove, right?
Only
Okay.
defendants can remove, because the plaintiffs are the one who filed. Like, if you filed in the wrong court, like, you're kind of an idiot. You know, the removal is a device for the defendant. Okay, and if there's multiple defendants, they need to consent to removal. Nice, Hannah. Any more little tidbits? Not that I'm anti-tidbits, let's tidbit it up. All right, so what's next? Civil procedure, probably evidence, if I know me. Oh man, look at me, as consistent as the driven snow. So evidence, in a case where a man is on trial for burning down his wife in a house, that's why I'm happily single. Both evidence of him threatening to kill her, not because I would do that to my wife, I just feel like married couples are having trouble these days. It's getting hot outside, you know? In a case where a man is on trial for burning down his wife in a house, both evidence of him threatening to kill her and of him secretly obtaining duplicate insurance are admissible as evidence of motive and consciousness of guilt. So dual purposes, that's one of the exceptions that, like, you can show duplicate insurance for evidence of motive and consciousness of guilt, because motive it was before and consciousness of guilt for having the duplicate insurance. Mandatory presumptions are inadmissible in criminal cases. We must prove beyond a reasonable doubt that the man is dead in a criminal case. He's likely in Tijuana with his new girlfriend and faked his death. Sorry to hear that if your husband is missing. I actually am in a business networking group, and this dude is a private investigator. I can find anyone. So if you have a husband or wife who's been missing for many years, I got your guy. He's the man. I'm trying to remember his name right now. Shit, it'll come to me. He is a really, really cool guy though. A witness's propensity. Oh, what? There we go. A witness's propensity for truthfulness cannot be attacked by extrinsic evidence. For example, we cannot impeach a witness for truthfulness by bringing in evidence of specific acts, such as employee saying the witness falsified reports twice before. So propensity for truthfulness cannot be attacked by extrinsic evidence. And here's an example for that. We cannot impeach a witness for truthfulness by bringing in evidence of specific acts, such as an employee saying the witness falsified reports twice before. The employee saying that he did this, right? That's going to be extrinsic evidence to attack his truthfulness. Under the learned treatise exception, a jury may only consider the parts that are read by a witness or attorney. The jury may examine the entire book because of the risk of reading non-germane points The jury may not examine the entire book because of the risk of reading non-germane points that could impact their decisions. So in a learned treatise exception, the jury may only consider the parts that are read by a witness or attorney, right? An expert witness or attorney, because they can't consider the whole book because that would make them potentially biased. I'm like so focused on teaching right now, I can't even remember this dude's name that I see once a week, but it's gonna come to me soon. And he does privacy investigating. He's really the best in the business. A judge may only instruct the jury that they may take a presumption of something that is subject to judicial notice. Chicago and Kansas City being interstate. The judge cannot require that they must accept as conclusive evidence or that the burden of proof shifts to the defendant. So you can only, it's a criminal case, right? It's only that they may take notice, but not that they must take notice. A witness can testify about a robot that has been destroyed if the witness has personal knowledge of the robot and because the robot is not subject to the best evidence rule. So that's true. A witness can testify about a robot that's been destroyed if the witness has personal knowledge of the robot and because the robot is not subject to the best evidence rule, right? It's like personal knowledge. Yeah, I saw this robot. So what? You destroyed it. I could tell you it used to go like, right? Like I remember it used to do that. If a party creates a presumption that a letter has been received, the other party can rebut that presumption with evidence that it was not received. In that situation, it would be inappropriate for directed verdict, right? Tommy's saying you likely received it. This is the evidence. Johnny's saying, oh, I don't remember receiving it. Let's throw it to the jury instead of having a directed verdict. When in doubt and it's summary judgment or directed verdict, and it seems like it might be triable, let's try it out, right? I think going to the jury is the better answer. All right, I know like I'm not supposed to do this, you guys. I'm very anti having AED, but if I can't remember this guy's name, I'm not gonna be able to teach. So I have to figure this guy out. BNI Pinecrest, that's this organization I'm in. Should you join a BNI? Sure, if you want to wake up at 7 in the morning to meet people and network. See, there's me, Andrew Daniels with Abbas Prep. That's your guy. Where is this guy? Martin, fucking Martin Silver. There we go. Let's give him his day. Oh, you don't even have a picture, Marty? Come on, Martin Silver, private investigator.
You can't have a
He's a
picture.
guy.
He's a
Why would he
private
have a picture?
investigator.
Oh yeah, you guys already know.
Page.
Let's do some investigation, Marty. Ooh, 4.7. I wonder who gave him the bet. No, I'm just kidding. No, this is my guy though. He has police experience. He's the man. Over 29 years of law enforcement. There we go. This is the guy. Look at him. That's exactly what he looks like. He's a little more seasoned now. It's been some time. But oh, he took his shit off. He didn't want to be exposed. But yeah, that's Marty Silver. He's a private investigator. So if you need to find anyone, that's your guy. We found him. And I knew it was Marty. I kept in my name thinking like another old school name. But yeah, all right. Thank you to me for solving that mystery.
That mustache was something special.
He still has it, but now it's my gray. Marty Silver. He's a funny guy, man. I have him in a chapter with some characters. It's not easy being a businessman, but I like Marty. Marty's my man. All right, so let's talk about relevancy. Relevancy. Evidence is relevant if it has any tendency to prove or disprove a controverted fact. For example, evidence that a knife could have been the killer knife is admissible even if other knives could have been the killer knife because the weight of the evidence is a question for the jury to decide, right? Any tendency of fact, that's the standard for whether it's relevant or not. When it comes to authenticating evidence, for example, whether or not someone had authority to speak on another's behalf or whether a piece of clothing belonged to a defendant, the standard is sufficiently proving the standard is sufficiently proving that it is what it purports to be. So that's the sufficiency concept. That is the cocaine that fell out of his pocket likely to be Tommy's? Yeah, because it's sufficient evidence to link them together. Is the shirt Tommy's? Yeah, because there's sufficient chain of custody. Here, we're authenticating it is sufficiently what it says it is. A fisherman's logs of water records constitute business records which are admissible under the business record exemption. Furthermore, a summary of the records is also admissible, right? The fisherman, he's a real businessman. Y'all should be thankful next time you go to this omakai and eat your tiny little fish. The fisherman is the one who put in the real work. The Fifth Amendment right against self-incrimination applies in civil and criminal cases. Fifth Amendment right even applies in grand juries. That's the Dave Chappelle, I plead the fifth, right against self-incrimination. Double hearsay. The tenant said to the witness that the manager said a tenant, for example, if the statement itself is exception to hearsay, the outer layers would be inadmissible, and therefore the entire statement is inadmissible hearsay. So there's one about like notice of the carpet, and you're saying it, oh, it's an exception because it's not hearsay because it's to say they had notice. Yeah, but it's Tommy saying that Johnny said that statement, so it's actually double hearsay, therefore its entirety inadmissible. Prior bad acts are inadmissible to show propensity to conform with a bad behavior day. For example, we cannot show evidence of Tommy shooting a shotgun 7 years ago at a woman or evidence of him doing a drive-by with a handgun to prove anything related to him accused of sniping today, assuming there's nothing to show mimic. Motive would be inappropriate because it was 7 years earlier and a different woman, and identity would be inappropriate because it was different caliber guns. Now, motive and intent can come in, right? Like if Tommy and Johnny got in an argument and then the next day Tommy shot Johnny, well, we're gonna bring in the argument to show it's not self-defense, bro. You guys got in an argument. You tried to blast his brains away. And that's motive. What about identity? Well, I always like the Joker example. If you've ever seen The Dark Knight or Batman or anything, the Joker, if you don't know, is a villain. And when he kills people, he always leaves or ties them up or whatever. He always leaves his little Joker card, right? Like, let's say you're bringing in evidence of that Joker card to show identity. Well, yeah, we got a dead body, we got a Joker card. It's likely you that did it, the Joker. Oh, you're not allowed to bring in those bad acts. Like, no, we are bringing these bad acts of the Joker cards to show conformity with a mimic, right? Motive, intent, mistake or lack of mistake, identity, or common scheme or plan. So the hearsay exception for a statement made for medical diagnosis does not need to be made to treating physician, just made for the purpose of diagnosis or treatment to a qualified health professional. So if you're injured and you go to seek Miss Dr. Miami, my neighbor, and I live in a townhouse. Oh, sorry, they're my neighbors. They're nurses. But, you know, a few doors down, the daughter, I tutored her for the LSAT. Her mom's Pandora and her name is Santina. And Santina was the TikTok girl for Dr. Miami. And she got super famous. Now she's like a TikTok influencer, I guess. But let's say you go to Dr. Miami for advice for your incident, and he gives you advice, but then he turns out to be way too expensive. So then you go to like Dr. Louisville, Kentucky, who's more affordable. Well, the statements that Dr. Miami made to you for treatment purposes are still admissible, even though he didn't end up being the treating physician. Okay, so let's see.
Andrew, I had a quick question about that. So,
I'll say
no, so you said it's just any medical professional, right? That includes like EMS and stuff like that. If the person that's injured, if somebody else is speaking for them and telling the medical professional about what happened, is that hearsay, or is that does that still count as like a statement for diagnosis?
if the statement is made by the doctor for the purposes of giving treatment, then it will be an exception, right? Like it's looking at why did the doctor make the statement, right? And the reason why is because we're trying to see, is the statement going to be truthful? And if the doctor's, just making a statement for the purposes of giving medical advice, then we do think it would be a truthful statement. Let me see. Does anyone else have any difference of opinion on that question? I think that's the right answer, though. As long as the doctor's making it for the purposes of giving medical diagnosis, then it would fall under an exception. It's not really important who asked him for the advice. It's important about the moment of him giving medical advice. Yeah, that's what Hannah's saying. If they're a reasonable agent, then they can probably speak. Yeah, I feel like if that's the situation, if I'm hurt and my mommy is like, hey, doctor, Andrew's hurt. And the doctor's like, what happened? And my mom is like, he stubbed his toe, like he stubbed his toe sentence would come in. Okay. So let's not talk about me stubbing my toe and that. A statement is not a party opponent admission if the security guard no longer works for the defendant at the time the statement is made. A statement is not form of testimony if the opposing party was not a party to the case and did not have an opportunity to cross-examine the witness. So they test that a good amount, where it's like, oh, you think it's a party opponent statement because they're an employee, but they're actually a former employee. If they don't work for them at the time they're making the statement, then it's not a party opponent admission. And again, it's not former testimony if the opposing party was not a party to the case and had an opportunity to cross-examine the witness. That's why we allow informer testimony, because they're already subject to cross by whoever they're bringing the case against, and that is a necessary requirement. So the judge is the gatekeeper for admissibility. The way the evidence goes to the jury, the judge may consider anything, including hearsay, in determining preliminary questions such as admissibility. So remember that preliminary questions are for the judge, not the jury. The judge can consider hearsay. Like, trust me, I feel like the judge in a lot of things that go on in my business. Like, a lot of y'all send me stuff and you're like, hey, Andrew, this would be really great for the class, this material. And it's like, Tommy colored a bright blue crayon that said like personal jurisdiction. And I'm like, this isn't going to be helpful. I'm the gatekeeper. I'm allowed to see it, but that doesn't mean the whole class is going to see it. Same thing with the case. Like, the judge is the guy who, he's allowed to hear and see anything. He can get all the gossip. He can get all the hearsay, whatever. She can get all the hearsay. She can hear all the gossip, whatever. And then she can decide whether or not it's appropriate for the jury to hear it. So the judge determines preliminary questions of admissibility, and the judge can consider anything, even hearsay, in that determination. So relevance is probative to allow evidence of not having back pain before a car accident to prove that the back pain you have now was caused by the accident, right? Certainly relevant. Prior statements of identification are admissible as non-hearsay. So, for example, a statement of identification made to an officer at a lineup from a witness is admissible. Furthermore, in order for a prior identification to be admissible, the declarant must be testifying in trial and subject to cross. Right? I think, Eduardo, were you the student who asked when my last video was going to be on YouTube? Just remember that. So
Yeah, was me.
I think it should be now. I just started loading up this morning, so by the
Thank
time this one's over, you can watch that one. And then I told my guy that we should try to upload this one before
Awesome.
the day yet too. So
Thank you so much.
remember to like, subscribe, and
Of
whatever.
course. Thank you so much.
No, thank you, man. Okay, so a prior inconsistent statement is admissible to impeach if the declarant is not subject to cross because it's unavailable for example, right? Motive is a mimic exception. You can ask a wife about her previous times running in fear of her husband as a motive to testify falsely against him today. Make sure you understand mimic and what that means. A hostile witness who is available to testify is still available. Therefore, the statements against interest hearsay exception would apply, as it only applies when the declarant is unavailable, right? It would not apply. Sorry, the statements against interest hearsay would not apply, as it only applies when the defendant is unavailable. Remember, party opponent admission is unavailability is immaterial, but statement against interest, they must be unavailable for it to apply. Multiple hearsay. This is tough. So each hearsay statement must be admissible on its own. For example, a statement that a resident told a tenant that he told the manager about the defective carpet. This is the exact question I alluded to. The statement to the manager is admissible as non-hearsay effect on listener for notice, like I said earlier. But the statement from the resident of the tenant statement is inadmissible hearsay, right? Hearsay within hearsay. A defendant cannot establish good character through specific instances, only reputation or opinion, unless character is at issue, like defamation. Like, we can, if I'm at, being sued for defaming Rosie for saying that Rosie's a thief, and then I want to bring in evidence of Rosie stealing the biscuits off the table, right? Right, Rosie? Then that is admissible because character's at issue for like defamation. It's also admissible for like sexual deviant crimes or acts. So judicial notice, it's gonna be must for civil. And I told my class one year, I was like, I guarantee this will be tested. It's tested every year. That judicial notice is a must standard for civil. You must take judicial notice of the fact, and the jury is required to accept it as conclusive. And may for criminal. You must take judicial notice of the fact, and the jury may, but is not required to accept that as conclusive. I was like, just remember that. Must for civil, may for criminal. I guarantee you get 1 point right. Because like I said, I've taken the bar 4 times and I've seen it 4 times. I was like, they'll definitely test this one. And then I asked some people, I'm like, hey, did they test that? And they're like, nah, they didn't. And I'm like, you can't really predict what they're gonna test, is my point. So like I try to tell people what to expect, but just expect the unexpected and be prepared for everything, and you'll do just fine. It really is a low-hanging fruit test. It's one of the only tests in your life that if you get like a C, you will crush it, right? If you get a B minus on this test, you'll get one of the top scores. Like if you actually get an A on this test, then you'll be like put in the Hall of Fame. So it's like not that hard of a test to pass in terms of like number you need to get right. It's just a lot of stuff they could potentially test. And I know that's overwhelming. So that's why I do these cram guides. If you could just cram these points in your mind, I think this is more than enough. Okay. If a party inadvertently discloses confidential information, it must request it back in a reasonable time, not the day before trial. Furthermore, if a party inadvertently discloses 2 of 25 pieces of confidential material, it has no duty to turn over the other 23 pieces, right? It does have to turn over the 2, but not the other 23. A party opponent admission is admissible as an exemption to hearsay because it was made by a party or their agent, employee, etc., and is being used against them by an opposing party, right? Party opponent admission could definitely be used by an agent or employee, but not a former agent or employee. It has to be a current one. Under the business records exception to the hearsay rule, there must be someone with knowledge to lay the foundation, either the person who made it or someone who was there when it was made. Usually the transaction is routine. So this is the business record exception. And we're not going to allow in business records for things that were made in anticipation of litigation, just things that were made in the ordinary course of business. When I took the MBE for the first time in 2017, I walked out of there, and I'm not going to talk about Florida because that was a whole different harrowing thought. But my scary thought when I walked out of the MBE, I had 2 thoughts. Was if I failed the test, it's because I didn't know hearsay and I didn't really understand murder. I remember thinking that when I walked out of the test, like I thought I knew those subjects going into the test, but they tested them in such weird ways that I was like really on the edge of questions for hearsay and murder. And then, you know, obviously I've had the luxury of taking multiple tests, multiple jurisdictions, and I've gotten to work on things. So turn weaknesses into strengths. But when I took my first bar exam, that's what I walked away with. So I'm just telling you all that. Then when I took my second one, I remember thinking, wow, they tested a lot on mortgages. So, you know, that's a takeaway. Mortgages. When I took the third MBE, I remember thinking this one question I took like 5 minutes on. I was so furiously stuck on it, which was an amateur skier, right? An amateur skier caused an accident. Will he be held to this duty of care of a normally prudent amateur skier or a normally prudent skier, or 2 other ridiculous answers? And I was so stuck, I couldn't figure it out. And the answer is a normally prudent skier. You don't get a decreased standard of care for being an amateur. If it would have been an expert skier, you will be held to the standard of care of an expert skier, but an amateur skier or a regular skier will both be held to the duty of care of a regular skier. Then when I took the 4th MBE, the takeaway I had was like, first off, I felt like the paper was on fire. I finished it so fast. It was awesome. I felt like a true master of the material. But there was 2 questions that really bothered me. And they were both about judicial notice, about, you know, the clerk can only enter it if it's a sum certain, and about like when can a default be entered versus default judgment. It was just like a couple questions on defaults that I was like not 100% sure on. And then I kind of went back to clarify that. So those are some of my takeaways of things that I recall troubled me on my experiences with the MBEs were hearsay, murder, mortgages, duty of care, and default judgments. Okay, so let's continue. Noel, you're saying that the skier, I think that was when I took probably California, so it was during the pandemic. So if you took a test during the pandemic, maybe you saw that question too. Okay, I'm not supposed to be looking at the chat. So anyway, what we're talking about, prior bad acts are inadmissible to prove propensity to commit crime accused of. However, they may come in for any other purpose. This is the mimic rule: motive, intent, mistake, lack of mistake, identity, common scheme, or plan. You can bring in prior bad acts for rape or molestation. In federal law, police reports are business records that may be accepted from hearsay. However, if the record contains hearsay statements, it's inadmissible, right? The police report can come in as a business record. If you're in my Florida case, shut your ears, don't listen to that. But the next part is true regardless. If the police report comes in, but it has hearsay statements, like the police report has a statement from Charlie saying Tommy shot the gun, we're not going to bring it in because hearsay within hearsay. The federal rules of evidence do not apply to probation, revocation, hearing proceedings. Let's get that one right. The federal rule of evidence also do not apply to grand jury proceedings. Oh, here we go. Similarly, they're not applied to grand juries, extraditions or renditions, summons, arrest warrants, sentencing hearings, or bail hearings. These are all places where the rules of evidence do not apply. But you do have privileges, like you do have your attorney-client privilege, and you do have the right against self-incrimination. The rules of evidence do not apply to hearings for determining admissible evidence, for example, whether an expert witness qualifies as an expert. A prior admission can constitute an inconsistent statement. For example, if someone fails to mention alibi earlier when given the chance, but mentions one later, this can constitute a prior inconsistent statement via omission. An excited utterance is an exception to the hearsay rule. When a statement is made under stress, excitement of the moment, it usually ends in an exclamation point. Dying declaration, declarant must be unavailable and can only come in for civil cases and criminal cases concerning homicide. Now, unavailable, that doesn't mean they're actually dead. They could be in a coma, they could be out of the country. They just need to be unavailable. And it's not going to come in to allow them to be like on my deathbed, Tommy owed me $1 million, like it's not that. It has to be like, oh my God, a big meteor is coming at my head. Like it's got to be like something like that's what the dinosaur said, right? Was this the class I pulled up the dog jokes in, or I think that was my Florida class? Yeah, my class was getting so long yesterday that I pulled up dog jokes on the internet. They're pretty good. I'll probably do it again today. I like dog jokes. Okay, so we can ask a witness testifying on behalf of a defendant's truthfulness if the witness had heard a defendant cheating in medical school, because it's probative for truthfulness or probative for lack of knowledge of defendant. So you're saying that Tommy's a truthful guy. Now we're going to ask you, did you know that Tommy cheated on his medical exams? It's definitely allowable, because if you say yes, then he's not a truthful guy. If you say no, then who are you to talk about Tommy? You don't even know about him cheating, the big scandal of 2012? Like what? All right. A defendant on trial for arson and murder of ex-wife. We can bring in evidence of duplicate insurance to show motive for arson, and we can bring in evidence of threatening to kill the wife if she threatened to testify for consciousness of guilt or planned and knowledge, right? So arson and murder, we can bring in evidence of duplicate insurance to show motive, and we can bring it for consciousness of guilt. This is a, we repeat. Under the best evidence rule, if a party is trying to prove the contents of a record, we must bring in original or authenticated duplicate. We will not allow secondary testimony about the contents of the record unless it is shown the original cannot be procured. So best evidence applies to photographs, documents, recordings, x-rays, and it's when we're trying to prove the contents of it, not when, something you have personal knowledge of. It could be a tough one. So make sure you look at like, what are they trying to prove? What was said on the letter? Or is it just something that we could just be like, oh yeah, I know that Tommy fired Johnny because, Johnny was a bad worker. Like we don't need the letter to prove what you have personal knowledge of. So you don't always need to bring in the best evidence. Duplicates are usually going to be fine. Just if they're trying to bring it in for the content of it, we're not going to allow it. A woman arrested for cocaine who says that she got the cocaine from another supplier. It's a very tough question. We cannot admit the testimony because it's self-serving, not a statement against interest, even if she's now unavailable. So this one is like, okay, the lady's selling drugs, just like most rich people in Miami, and she is not good at it. She got caught, right? And then when she gets caught, the police are like, oh, where'd you get the cocaine? She's like, I got it from Tommy. Well, that's actually it's a self-serving statement because you're passing blame over to Tommy. I don't love that question, but that's how we're going to interpret that. That self-serving statement is not a statement against interest if you're shifting blame over to Tommy. In a product slide, is anyone in my class named Tom? All right, good. I feel like I've been beating Tommy. Tommy's like my Dan Marino, but me, I love Dan Marino. I would never, ever talk poorly about him. Remember that. If you know Dan Marino, I need to meet him, toss the old pigskin. I need him to throw me a deep pass, and then we need to talk about how we can help make bar prep amazing forever. So in a products liability case alleging a defective steering wheel, we can bring in evidence of a wife being intoxicated while driving as evidence of an alternative theory of liability, right? The wife's up there and she's saying like, oh, the steering wheel is defective. And we're like, lady, you were drunk. Like the steering wheel worked pretty good. Expert may give opinion so long as qualifies as an expert. We're gonna use the Daubert standard in federal law as opposed to the Fry standard. So they have to be qualified based on, it's a judicial standard. That's the difference between Daubert and Fry. Fry was a community standard. Daubert is a case-by-case standard. It gives the judge more discretion to let them in so long as they're an expert who pretty much, is qualified. They have special knowledge and skills, and maybe they publish some books and things like that. I feel like I'm an expert of a few things, but who knows? A trial judge has broad discretion over the order of examining witnesses. Okay. It's okay to bring in evidence that the man and the father had quarrels to show intent in a case where the man shot his father accidentally, right? Like it wasn't accidentally, it was intent. Remember, mimic. The judge court determines questions of admissibility and may consider evidence that may otherwise be admissible, such as hearsay. Statements made for assigning liability are not made for the purposes of obtaining medical treatment and thus are hearsay, right? Like, Tommy hit me in the blue truck when he ran the red light. That's not going to be a statement that comes in because you're saying he ran the red light. You assign blame to Tommy. A party opponent admission is admissible if made by an employee within the scope of employment duties as an agent of an employer. So a party opponent admission is admissible if made by an employee within the scope of employment duties as an agent of an employer, right? A judge may never testify in a trial in which she is presiding. A witness may be impeached by a prior inconsistent statement, but the statement cannot come in for substantive purposes unless it meets all requirements, including that is not hearsay. The scope of cross-exam is limited to material and direct and the credibility of the witness, right? That's what's limited. This can't be outside the scope of what's on direct. Information acquired by a judge via phone call from a clerk cannot be considered judicial notice. Only reputation of a person's character that is relevant to the crime can be brought in. For instance, in a trial for murder, only can bring in evidence of peacefulness, not truthfulness. A lay witness cannot become familiar with the person's handwriting for the purpose of trial. I just remembered I was thinking of these YouTube videos that the video I put up on YouTube most recently starts off with me as a fox. If anyone remembers that, if anyone's in my Florida class, I like manipulated the world to turn me into a fox. Let me see if I can do that right now. Maybe that'll bring some entertainment to this otherwise boring session. What animal should I be? A fox, a cow, or a dog? I feel like dog is the best, man. I just have that dog in me. All right, I'll do a couple as the dog. So, a lay witness cannot become familiar with the person's handwriting for the purpose of trial, right? So you cannot become familiar with a person's handwriting for the purpose of trial, but you can become familiar with the sound of their voice. So if you already had familiarity with their handwriting before the trial, then sure, like if you're a bank teller or whatever, you could be like, yeah, this is their handwriting. But if the trial starts and now you're like, oh yeah, since trial I became familiar with their handwriting, not acceptable. But you can be like, oh yeah, since trial I became familiar with their voice, that is acceptable and admissible. Evidence that would not be admissible to show conformity with a crime may be admissible for other reasons, such as to show the identity of the Percodan pharmacist. That's definitely straight from a question. I don't know if Percodan is a real thing or not. When I'm president, one of my number one, this dog running for president. When I run for president, one of my number one campaigns is going to be solving the opioid crisis in America. That really is like something we don't address enough. And I think it's an underlying cause of like homelessness and a lot of things that should be addressed. So vote for me, the dog. Okay. So I don't know what Percodan is, but it doesn't sound like something good. Saying or writing, I intend to do something on a certain date. And Erica, we did this one this morning, is an exception to hearsay as a then existing mental, physical, or emotional condition. So if you see a letter, like I intend to do this on a certain date. I intend to go to Tampa tomorrow. I can't believe I'm really going to Tampa tomorrow. It's really come. And my dogs are coming too. So if you want to come hang out with me, I got a pool, I got an Airbnb, me and my dog's gonna be chilling. I intend to do something. I intend to go to Tampa on a certain date. If I write down a letter, it's gonna come in as a hearsay exception for then existing mental, physical, or emotional condition. It is admissible to present evidence that someone was a thief if it's a defamation case because character's at issue. You can use character evidence when character is at issue, right? Like, yeah, it's defamation. I can show that Rosie stole the treats. Earlier when I said biscuits, I was like, that's confusing because Biscuit's name is Biscuit. But if I told you all the story about why Biscuit's name is Biscuit, it's just a whole nother world we're gonna avoid right now. So whether a presumption is applied is determined by the law of the state in which the substantive law is applied. So presumptions are substantive state issue. You know, if it's a presumption, we're gonna look at the state law. A recorded recollection with the proper foundation used to refresh memory on the stand can be read into evidence if the party requests. So it's a recorded recollection. Now, if it's just used to show the refresh their memory on stand, that's not going to be read into evidence. But if it's a recorded recollection with the proper foundation, then sure, that can actually be read into evidence. What is a recorded recollection? It's accurate when made, and they currently have no memory of what was recorded, right? So that's a recorded recollection. If it's something you said was accurate when it's made and you currently have no memory of it, then we are gonna allow it to come in as a recorded recollection. All right, let's see if I can make y'all laugh more. I don't even know what this animal is. What am I? Does anyone know what I am right now?
Squirrel?
I don't think squirrel.
Are
What's
you a
the-
dingo?
What is this and this and this? And this? What the fuck is this? All right, I'm gonna go with this one for a little bit. This one makes me feel good about my life. Okay, so what am I? I'm a recorded recollection. And what is a recorded recollection? A recorded recollection is something that was accurate when it was made and you currently have no memory of it. We are going to bring it in as an exception to hearsay. Evidence of bias is admissible to impeach, such as evidence that the witness was challenging the leadership of a gang and is now testifying against the gang leader. So for this one, if you see bias as an answer, you know, look at it, see if it is the right answer, because it does tend to be a common answer often. So the Fifth Amendment may be invoked in civil or criminal cases, but in civil an inference may be made. In criminal, and no inference may be made by invoking the Fifth. Collateral admissions, a statement of fault made in conjunction with a statement regarding the profession of liability insurance is admissible. The statements can be bifurcated, split, so the admission of fault is admissible, while the statement regarding possession insurance is inadmissible. So a statement of fault in conjunction with a statement regarding possession of liability can be bifurcated. Some statements can't be bifurcated, like if it's a compromise or something. If it's ordered to you know, if it's a statement about liability insurance, then we could bifurcate it. All right, let's see. Do you guys like me more as a human or an animal? I won't feel bad.
Animal, please.
Animal? Can you pay attention with me? What was I? What was I right there?
I honestly think that like it was a gray fox when I said squirrel, but you were a polar bear for a minute there, huh?
This right here is a polar bear?
Yeah, definitely.
Polar bear? All right, let's go. So properly authenticated, which is easy, photographs from the crime scene are admissible because they're relevant, right? They're properly authenticated. What would fail the balancing test? If it's confusing, unfair prejudice, or cumbersome. Surprise is not an element. So if it's confusing, confuses the jury, unfair prejudice, it would cause delay, that's going to be failing the balancing test. Remember, 403 balancing test, it needs to, the probative value cannot be outweighed by the prejudicial value. Party opponent admissions could be admissible as impeachment and substantive evidence as an exemption to the hearsay rule, right? Party opponent admissions at federal law are exemptions, where statements against interest are exceptions that require unavailability. We cannot bring in evidence of 2 past robberies to show intent or identity for a current robbery because the probative value is outweighed by the prejudicial value. There's no common scheme or plan or identifiable feature. Hospital records related to the treatment are generally admissible as regularly recorded business activities. So sometimes people get this wrong. They confuse you because there'll be a hospital record and they'll say it says, you know, for the purpose of medical treatment. It's not. It's a business record. Hospitals are still businesses. Lord better believe that. That's one of my actually that's like my fifth prong as president. My first one is end the student loan crisis. Man, I'm gonna do that one first. Second, opioid. Third, prisons. Fourth, I want to work on the military. And then fifth is hospitals and healthcare. I got a lot of issues in mind that I want to solve, but let's focus on your issues, which is passing this test. And hospital records, hospitals are a business, unfortunately, in America, big business, and they are business records. If they just have some statement, it's a business record. Now, if it's a statement for medical diagnosis, then that would be a different story, and it would still be an exception for a statement for medical diagnosis. I feel like I'm allowed to say much more political things when I am an animal. All right, now that I'm back to a human, let's get serious. Let's see what's going on in this chat. 24 questions. Okay, 24 statements, but a lot of it is about whether I was a dingo. Maybe the dingo ate your baby. Did anyone get that reference, or that's 90s? Does anyone get that reference?
Seinfeld.
Yeah, all right. People gotta watch that one forever. Maybe the dingo ate your baby. All right. So quick note is I didn't want to prolong the earlier discussion. There was one question where the husband was asked by the doctor what happened to his wife. The husband replied that his wife was hit by a crazy driver. I remember being proper to answer the question. The statement would be inadmissible hearsay, right? Because it's assigning blame. Yeah, we kind of talked about that. The doc doesn't need to know what the driver was. They're crazy to treat them. Yeah. All right. You guys are calling about that. C's get degrees. That is true. Andrew has seared the amateur skiing question in my mind. Yeah, I seared that one into my mind too. Does anyone have a mnemonic for remembering hearsay exemptions apart from exceptions? So exemptions would be exemptions like party opponent admission, a inconsistent or prior inconsistent or prior consistent statement. Wait. Prior consistent statement, or let's see what we got. Oh, fuck, Zach got it. I can't poop. I'm excluded if I can't poop. Okay, perfect. Thank you for that. That'll help me do this better. So prior statements of identification, prior inconsistent statement, and opposing party statements. Oh, I was 3 for 4. So yeah, that's exemptions. Prior statements of identification, prior inconsistent statement, prior consistent statement, and opposing party statements. So if I can't poop, I'm excluded, right? That makes a lot of sense, I guess, if you guys can picture that. So this is great, Zach. This is so funny. I'm going to remember it. I'm simply the learned intermediary. Shout out to someone. Bank tellers are not experts in handwriting. Their personal experience with the fraudster's handwriting can come in because it'd be helpful for the jury, right? They're not experts, no way, but they have familiarity with the handwriting as a lay witness. So something's awesome. Oh, I think that was me turning into an animal. Still think it's bullshit in real life. It's not how it works. Erica, what are you talking about in real life?
You were asking, you were saying that we just did that question today. And I was like, I still think that it's bullshit and it's not like that in real life, but for some reason I'm blanking on what that question topic actually was at this moment because there's so many of them that I think are bullshit would never happen in real life.
It's this one right here. I intend to do something on certain,
Yes.
like you write in a letter, that's a classic existing mental, physical, emotional. I intend to go to Tampa tomorrow. I intend to really chill and relax while you all take this really difficult exam. I intend to do some nice networking, right? All these things I say in the letter would be, I intend to do something on a certain date. Remember how I was telling you in our session 2 that I had this problem with just saying everything that's on my mind at all times? I haven't solved that since our session started. Okay, so no, I think I'm gonna run with my friend from college, An Hussein. I just feel like it would be good. An's the man. I don't know. I could do a female candidate too. I could do any candidate. I haven't picked my vice president yet. I probably it's like how politics work. I have to beat someone and then I choose them to be my friend. It's kind of a weird thing, right? Like I just trashed you in this debate. Now I want you to run with me. Really weird political system. As you guys all know, I'm definitely running as an independent. I was the original independent. I see people now are independent. I was independent first. Not that I cares. Okay, so gray fox, dingo, maybe the dingo ate your baby. Okay, Hannah's saying recorded. Comes in as evidence and can be an exhibit if the opposing party asks. Refreshing does not come in for evidence. If a party uses the refresh before trial, the defendant may see it. If a party uses refresh during trial, the defendant must be able to see it. Yeah, that's just about being able to see it. That's not about reading it into evidence. And that is true. If they use it, then they're definitely have to be allowed to see it. Fox, gray fox, field mouse. Yeah, I like mice. I'm big into mice. I've told a lot of stories about mice. 3 mice stories. Polar bears. What would the voice testimony be like? Would a witness say, since the trial started, I've been listening to their voice recordings. I can now testify that they're the same person who spoke in that audio recording? Yeah. Since the trial started, I've been listening to them on the stand, and I can tell you the person in that voice recording is the same person I've listened to on the stand, like something like that. Like I've become familiar. Yeah, Hannah's saying, yep. All right, Shauna's telling us about Perconin. The one question we all were challenging, we were on the pharmacist and liability where we filled a fraudulent script. We voted about 10 minutes. This was the crash course about 3 weeks back. Okay. Yeah, see, you guys were all on Perconin. You can't even remember the Perconin question. Regarding civil 5A inference. Oh, here we go, Zach. A court may draw an adverse inference against a party who asserts his Fifth Amendment privilege in a civil matter because the invocation of privilege results in a disadvantage to opposing parties by keeping them from obtaining otherwise information they could otherwise get. Exactly. So you think I'm a polar bear? Thoughts exactly. You're not even looking at me. You're too busy highlighting and writing notes on your paper. That's good. Andrew Dennis, Thick Boy 2028. Let's get it. I don't know who my running partner would be. I think it would be On, but I need to talk to him. He's been saying a lot of wild shit in my group chat. Not wild, like he has 2 kids and he's like a Pakistani. Like he's not wild, but wild for my taste. So conservative that it's wild for me. Okay, let's talk about criminal procedure and criminal law. Yeah, let's do it. Do I have MBE predictions? Okay. Let me talk about MBE predictions. I feel like corporations, partnerships comes up a good amount. I feel like real property should come up. I feel like because you and Kelsey needed help with that one, tort. So what I say so far, real property, torts, corporations, wills, civil procedure, and like, oh, Crim Pro, like the 4th, 5th, 6th Amendment, like Tommy was smoking dope in the parking lot and they searched him. All right, those are my predictions. Okay. Okay, let's talk about criminal law, criminal procedure. Yeah, property, torch, corpse, will, Cipro, Crim Pro. 1, 2, 3, 4, 5, 6. Yep, that's it. And 2 MPTs and a partridge in a pear tree. All right, so criminal law, criminal procedure. So asportation constitutes the moving of a person, and a kidnapper can be convicted in any state, even multiple states where asportation occurred. Arson is not a specific intent crime. And if you light a fire and it's going toward a house and you could easily put it out but choose not to, this will satisfy the mens rea necessary for arson, recklessly disregarding an obvious risk. So you don't have to actually specifically intend to, you could just recklessly disregard the obvious risk and you will have the mens rea for arson. You cannot be convicted of robbery if you mistakenly, perhaps you were drunk, think the thing you are robbing is actually yours, like a suitcase on a bus, right? Trying to recover something that is yours will take out the mens rea in a lot of these crimes. Involuntary intoxication will negate intent for a crime such as battery. So a good defense to battery would be that your coach gave you a drug and told you that it was merely aspirin, showing you were involuntarily intoxicated. Under the unilateral approach, right? So that involuntary intoxication is a good crime because battery, you're not liable for battery or guilty for battery if you were drugged. You didn't have the intent element. Under the unilateral approach, a woman can be found guilty of conspiracy to commit a crime if she believes she has an agreement in place and paid money, for example, even if the other party is an undercover agent. So the modern approach is unilateral. Common law is bilateral, where you need 2 parties to agree. It is unconstitutional to sentence someone to death who is intellectually disabled. The threshold under the Supreme Court is 70 IQ. Below is disabled. Is there anyone here who has an IQ below 70?
Yeah, right here.
I knew you were gonna fucking say it was you.
I
That's
think it's 70. I can't add. So, but yeah.
That just goes to show, man, I'm one of the great of all time that I can get someone with such a low IQ to pass this test with such flying colors. But we couldn't send Rob to death. Rob can run our country. Rob could be president, but we couldn't sentence him to death. So encouraging to flee is not aiding and abetting. And if you're not guilty of any crime, if you encourage a criminal to run away, like, I mean, just in general, man, you can't be guilty for encouraging a criminal to run away. We are all guilty of that. If you ever see on TV, me and my friend Tariq and I were at the gym one day watching this live chase go down. And like, of course, we're rooting for the car to like get away from the cops. It's just like the nature of humans, you know? So that doesn't make us criminals because we were cheering him on. He definitely didn't get away. It's really hard to get away these days with all the drone surveillance and things like that. Like, somebody's watching you. Okay, so let's talk about it. A police officer may rely on a defective or invalid warrant so long as it's in good faith. That's the good faith exception, right? If it's a defective warrant, but they thought it was good faith, then they're allowed to rely on it to, pursue. Impossibility of fact is not offense to an attempt crime. You can be guilty of attempted robbery even if the person you are attempting to rob has no fear of you, right? False pretenses and larceny by trick require some form of fraud or deception. So obtaining money because you made someone feel bad for you would not be either of those crimes. Right? Obtaining money because you made someone feel bad for you, right? Like if I came up to you and I was just like, hey, my life sucks. Woe is me. Can I have some money? And you gave it to me. That's not larceny by trick or false pretenses. Attempt murder manslaughter is a specific intent crime, so you cannot be found guilty of attempted murder unless you specifically intended to kill the person. So I don't know if she's here, but Zalpa, she submitted her album cover, and I put all the album covers on Instagram. And again, it is not a fucking political support. I told you I'm independent. I don't vote for anybody unless I want to. But it was a picture of Trump and, with his fist up and the blood on his ear, and her poster, her album cover was attempt. And it was like intent, satisfied, crime, incomplete. Like whether or not you care about the political message is not important to me, but the learning about the crime was solid. Like they attempted to murder him. So there was the attempt there, but it was not murder because they didn't actually murder him. Now, if the dude on the roof was just trying to shoot a bird, like not like you gotta shoot a bird, but not trying to like if he was trying to like shoot a flying bird and it just whizzed by, whatever, that's not going to be attempted murder because he didn't have the specific intent to commit that crime. All right, cool. So if police have an arrest warrant and they come up to the house and it's obvious there's no one living there or possible inside, it's boarded up and abandoned, and the neighbor says no one has been there in months and the grass is not mowed, then it's unlawful to break in and anything seized will be suppressed because the police had no reason to search the house, right? If it's a boarded up abandoned house, they can't search it because they have to have some probable cause to search. Miranda warnings must be given before a custodial interrogation. For example, if the cops bust in and arrest you and you give an incriminating statement in response to an interrogation like question, you can likely argue that the statement should be suppressed as a violation of Fifth Amendment Miranda rights. So, right, they have to ask you, you have the right, they have to tell you have the right to remain silent. Anything you say can and will be held against you. You have the right to an attorney, and if you cannot afford one will be provided for you. If they don't say that or something of that nature, then any incriminating statements they solicit could be suppressed as a violation of the Miranda rules. Strict liability will apply for the sale of alcohol to minors, for example, and vicarious liability would apply to the store owner in an example where both the clerk and store owner are guilty for selling alcohol to a girl with a fake ID. That would be like they applied strict liability and vicarious liability to hold the clerk and store owner liable or guilty for selling alcohol to a girl with fake ID. If you see me keep mixing up those words, it's because, man, I teach a lot, it's a long day, but remember, liable is for torts, guilty is for crimes. We're in criminal universe right now. A person cannot be found guilty as an accomplice if they had no guilty mental state. For example, a passenger in a car and the driver stops at the gas station to rob a bank, right? Like they're not an accomplice, they were just a passenger in the car and the driver was the criminal. They had to have some guilty mental state. A co-defendant's inculpatory statement against another defendant is inadmissible if the co-defendant who made the statement is not subject to cross-examination under the confrontation clause. The threat, force necessary, so a co-defendant's inculpatory statement against another defendant is inadmissible if the co-defendant who made the statement is not subject to cross-examination under the confrontation clause. So this comes up a little bit, like the co-defendant statement, if they're not subject to cross, it's inadmissible, and we're not gonna put the jailhouse snitch to get statements because that would be a violation of your right to counsel. So it's kind of hard to get the snitch to speak. I mean, it can come in certain circumstances, but there are all these caveats where they have to be subject to cross and it can't be elicited in jail by a undercover jailhouse rat. The threat, force necessary for robbery must be contemporaneous with a theft. It cannot occur weeks after in defense of stolen property. Then it would just be larceny, right? Like you can't, I can't swipe your book and then it was just larceny. And then 2 weeks later, you come and you're like, hey, Andrew, give me my book back. And I'm like, oh, yeah, fight me for it. And then I hit you with the old 1, 2, 2, 1, 3 or something. That would not be robbery because it wasn't contemporaneous. It was just larceny and then probably battery, but like separated. Using deception to obtain a watch is not false pretenses because you have not obtained title. So remember, false pretenses is title. Larceny by trick is just obtaining possession. Cash is actually title because you can spend the cash and you have title. To get the title to the watch, you would need some certificate of title or something of that nature. If someone tries to stab you, you're likely privileged to use deadly force in self-defense, right? If someone stabs me, I'm pulling out the blicky, right? Like, I don't know, but that's the concept there, that they're using deadly force, so you can meet deadly force with deadly force usually. A defendant may be compelled to make a voice recording or speak for identification purposes, and this communication is not compelled or testimonial. Murder can be a general intent crime as long as not first degree premeditated, which is specific intent. Arson and attempt are specific intent crimes. Remember, we talked about arsons, it's a specific intent crime, but it could be reckless disregard for like not putting out the fire. And then attempt, like you have to actually, it's specific. Who was it? Was it this morning? No, it was yesterday. I had 2 students overlap and I was doing this thing. I just feel like I've been teaching for like 3 months straight for like nonstop. But I had students overlapping yesterday, so I would just have them do 10 questions together. And I saw them get 1 question wrong, and they were like, Andrew, come help us. And I was like, what's up? And they're like, why isn't this the right answer? It's statutory rape. Can Johnny be guilty, or let's call him Giddy? Can Giddy be guilty of statutory rape because he had sex with a 15-year-old girl? And the answer is, well, the question said attempted statutory rape, and he didn't attempt to violate the statute. He could be guilty of the statutory rape because he's strictly liable, but not of the attempted, because attempt is a specific intent crime. So Giddy wouldn't be guilty. Giddy would not be guilty of attempting statutory rape. Giddy would be guilty if he followed through with it of statutory rape, but be careful, attempt is a specific intent crime, right? Okay. You guys can put the mnemonic in the chat, right? Like a student can always fake a laugh even for ridiculous bar facts. Okay, cool. So let's talk about attempt, and not to hate on that dude, Josh Giddy, but I'm a funny guy. Okay, so if a person is breaking in to retrieve items stolen from, if you guys don't know, because some people are like, what the fuck is that? He plays basketball in the NBA, and allegedly he was like dating a girl well younger than him. So it's just a joke. Okay. If a person is breaking in to retrieve items stolen from him, this is not burglary because there's no intent to commit a crime therein, right? Remember, it's the breaking and entering with the intent to commit a crime therein. So if you break in and then you're like, oh shit, I'm here, I must commit some crimes, that's not burglary. That's going to be trespass and then the crime. It's burglary is the intent to commit the crime when you do it. Even if you just stick one finger in the window and you're trying to do some criminal activity, that would be burglary. If someone robs another and then tosses a stolen property to someone who is surprised but keeps it, the person who keeps the item is guilty of receipt of stolen property, like of a watch perhaps, because they're literally keeping stolen property and they know it's stolen. Evidence of intoxication is admissible to challenge the mens rea element of specific intent crimes, right? So you can't really be guilty of attempted murder. Like if the dude on the roof who attempted to murder Donald Trump was fucking shit-faced and hammered, he wouldn't actually be guilty of attempted murder, right? Unless he was just taking a few shots on the way to the roof to, liquid courage. And I'm not trying to make light of this situation. I'm not trying to make light of anything, not even Josh Giddey's situation. I'm just giving examples here. In 2024, I feel like I have to say that shit like every 4 minutes. Okay, so assault in some jurisdictions is a specific intent crime, attempted battery, or it could be a general intent crime. The majority of jurisdictions recognize assault as specific intent of attempted battery, but in some jurisdictions, they just have a general intent crime. That's important because why? Intoxication. Intoxication would be a defense to assault in the majority of jurisdictions, but it wouldn't in the minority of jurisdictions where it's not a specific intent crime. It is permissible to have a defendant walk across the courtroom to demonstrate conformity with the allegation of having a limp as identified with the criminal, right? We're going to make them have a limp and walk across. Rosie, what are you doing? I got to get this medicine that Vanessa sent me for Rosie. All right, let's talk about asportation again. Asportation is the movement of a victim, and a defendant can be guilty of kidnapping in multiple states if he moves the victim in those states. We already said that. Self-defense using deadly force is allowable only if it's reasonable to use deadly force under the circumstances. This is heavily tested. That self-defense, the standard is objectionably reasonable, not subjectionably reasonable. Like there's a lot of really deranged kids out there. Just because the kid thought it was reasonable to use self-defense doesn't mean it was. It has to be what anyone in those circumstances think it's reasonable. So it's not whether the defendant subjectively thought it was reasonable, whether it's objectively reasonable. That's when self-defense is appropriate. If you solicit someone to kill your mother-in-law, again, happily single, and agree to the plans just pending payment, for example, the act of solicitation has already been completed. If a kid falsely accuses a teacher of fondling her and the teacher commits suicide a year later, there's no proximate cause for death and the girl will not be guilty of manslaughter, right? It's too unrelated. There's no cause. He didn't commit suicide because of the false allegation immediately. Like it's just not the proper claim there. I mean, there might be a civil claim there, but it's not going to be manslaughter. A common form of manslaughter is the misdemeanor manslaughter, which for instance is reckless driving that kills another, right? That's the best form of thinking of involuntary manslaughter. Voluntary manslaughter, think of adequate provocation, walking in on the tutor with your wife, or think of voluntary manslaughter as imperfect self-defense. You slap, I stab. Someone slaps, Chris Rock, when he slapped Will Smith, if Will Smith would have really gone South Philly on him and pulled the gun and shot him, right? Then that would have been voluntary manslaughter, imperfect self-defense. It's a funny moment in history. So an out-of-court identification that taints an in-court identification is not admissible, right? Unless, and you have to look at all the answer choices, the prosecution can prove that the in-court identification is indeed reliable, perhaps by some unrelated means, notwithstanding the tainted out-of-court identification. So look for that answer choice. Like, no, we're not going to allow that out-of-court identification to identify them because it was tainted. However, if there's another way we can identify them, then it'll be allowable. If a person is hit over the head with a flashlight, they're allowed to spray the person with the fire extinguisher. It's kind of like a fair battle right there. It's like a little Pokemon matchup. Who do you got? The person with the flashlight, or the person with the fire extinguisher? I mean, the flashlight could like shine it in their eyes and like kind of and then hit them. But the fire extinguisher, you just hit them with a psh, and then you swirl it around and crack them over the head. I think if you give me the weapon, I'm going with fire extinguisher. Now, in this instance, the person already got hit over the head with the flashlight, so they're like a wounded duck. So like, who's going to win this fight? I'm still giving it to the fire extinguisher. Okay. There's no constitutional requirement currently that a state must offer an insanity defense, right? There's certainly no requirement on who has the burden to prove the insanity, nor that is beyond a shadow of doubt as a fair defense. So insanity could be clear and convincing evidence, or it could be anything. It doesn't have to be beyond the shadow of a doubt. That's only for elements of the crime, not for affirmative defenses. Laxatives are not poison, so a person who puts laxative in their boss's drink and the boss dies cannot be convicted of murder by poison, right? Reading comprehension. Do not take laxatives before the test, unless you really need to, I guess. If a person tricks a store owner into giving him the watch and he walks away, it's largely by trick, but not false pretenses because he never obtained title. We talked about that one. Embezzlement is the keeping of funds that we were legally allowed to manage. Embezzlement, if anyone was in my course last administration. Stealing money, stealing something, and then a week later defending your theft with force is not robbery because the battery and theft must be contemporaneous. We talked about that one already. You could not be convicted of both larceny and robbery because larceny is a lesser included crime in robbery. You could be convicted of larceny or robbery, but not larceny and robbery because the one pretty much merges into the other. It's a lesser included crime. The confrontation clause requires that defendant be given the opportunity to cross-examine a co-defendant whose confession is being used against him. The use of a non-testifying co-defendant's confession without the opportunity to cross violates the confrontation clause, right? We talked about this. Shooting rounds into the air is depraved heart, and if someone dies, murder is the appropriate crime. That's actually pretty solid ad-lib. Battery is general intent. Conspiracy is specific intent, right? Remember, specific conspiracy because even a bar student can always fake a laugh, even for ridiculous bar facts. A bar student can is specific, right? Conspiracy. If you are driving drunk 70 to 30, you may probably ask for an instruction on voluntary manslaughter. Sure. Burglary requires a trespass, not burglary if open to the public, right? You can't burglarize like a public park. You can't steal like sunflower seeds from the ground of the sidewalk. Mistake of fact is not offense to larceny. You can steal something that is actually being given away for free, right? Because you just had the intent to permanently deprive. That's the one about like the poster that you stole. Receipt of stolen property requires knowledge of stolen property, possession of it, intent to keep it. For instance, if someone steals a watch and you see it and then they throw the watch to you, that's going to be receipt of stolen property. Taking and intending to keep a man's wallet is larceny. Like, no shit. If you're drunk and involved in an accident, but the accident would have occurred without your involvement, your best argument is you didn't cause the death. You're not the but-for cause, right? Like the accident would have occurred even if you weren't involved. So even though you're drunk, you weren't the but-for cause. Under the retreat doctrine, you have a duty to retreat and may not use force if you can do so safely. But if someone's holding up their fist menacingly, then you can pull out the pepper spray as it's non-deadly force. Does anyone in here carry pepper spray around with them? I know at least some of you carry guns in your purses and on your desk when you study.
I literally just bought one for this trip just in case.
Pepper spray or a gun?
Pepper spray.
Nice. Have you tried it out?
No, not yet.
You should try it on Ian to see how tough he is. Don't tell my said that. But yeah, that's pretty cool. All right, cool. Pepper spray. Let's spray it out. Why are you're fucking live in Miami and you brought pepper spray for Tampa? Like, I feel like Tampa's way safer of a city. But whatever.
I've just never really traveled this far alone, like on the drive. So just in case.
I hear you, and you got to go through the Everglades, some swamp people out there. Like, yeah, you're smart.
Yeah.
All right, cool. Well, I hope your drive's going well. I didn't know you were by yourself, but
Yeah.
where are you right now on the road?
I have no idea, but I'm
Nice.
like 2.5 hours out.
Nice. I'm gonna leave tomorrow. I don't even honestly, it's just like I can't believe that I'm actually going to Tampa tomorrow. It still feels like the bar is pretty far away, but I guess as we all know, it's really not. It's coming up. All right, let's get back to work. So intoxication is a defense for specific intent crimes. Students can always fake a laugh, even for ridiculous bar facts. Damn, I memorized that pretty good. Solicitation, conspiracy, attempt, false pretenses, assault, larceny, embezzlement, forgery, robbery, burglary, and first-degree moida, right? That's a good thing to memorize. Those are specific intent crimes. And why is specific intent important? Because things like intoxication being a defense. Even a wrongly subjective belief that you're recovering an item is a bar to a claim for a theft crime. For instance, even if you do all the elements of false pretenses, but in an effort to get something you think was stolen from you, it's not false pretenses as you did not have the specific intent. If the standard is malice, there's no need for specific intent, just extreme recklessness, such as firing a shotgun into a bush where kids like to hang. Right, like that's pretty malicious. Adequate provocation, you slap, I stab, walking in the pool boy trainer tutor with my wife. right? Tutor was added this administration. You guys made that joke, and now I think it's hilarious. But I do virtual tutoring. You couldn't walk in on me, only virtually. I mean, I tutor some people live. That's whatever. Directed verdict is an issue for the jury to decide. Therefore, even the judge felt it was proper. The standards for the jury. Just a caveat: if I do tutor you live, you have to pay an extraordinary fee. So don't feel jealous like I didn't tutor you live. Like no one can afford me, but the most celebrity-ish. Okay, so directed verdict is an issue for the jury to decide. Therefore, even the judge felt it was proper. The standards for the jury, right? The judge doesn't decide directed verdict or not for the jury. A victim cannot be a co-conspirator. An underage girl cannot be convicted of conspiracy to commit statutory rape, right? Like, you can't say, oh, a 14-year-old girl was a co-conspirator to a rape. No, she was a victim. If you're charged with knowingly violating a statute, the best argument is that you mistakenly believe something that in effect made it so you didn't believe you were violating the statute. For instance, you're supposed to check IDs of people 17 to 22, but you mistakenly thought he was 24. You weren't even supposed to check it, so you didn't do the thing that would lead to violating the statute. You're not guilty of larceny if you're trying to retrieve something. In order to receive stolen property, the property must actually be stolen and must not have lost its stolen status. So if you and an undercover cop steal a car, it retains its stolen status. But if you steal a car and then the cops arrest you and you take the car and you use it in a sting, it has lost its stolen status. So when it's about receiving stolen property, look to see if the thing is actually stolen, because once the cops have recovered it and now if they're using it in a sting, it's not stolen anymore. So you couldn't be guilty for receiving stolen property. Murder in the first degree is premeditated, which can include a plan to provoke someone so you can kill them. For instance, you tell coworker a lie, so he brandishes a knife so you can shoot him, and this was his plan all along, then this is first degree murder. I feel like it's definitely the appropriate time for me to morph into an ambiguous animal. Oh, it tells you what I was earlier. My bad. I could tell you what I was earlier. So that was a polar bear. You are correct. This one was a wolf. This one is a raccoon. All right, you guys want to guess what this one is? This one's a panda, by the way. This one is clearly panda. Let's go with panda. Okay, so if you have an arrest warrant and are looking for an accomplice, it's okay to go downstairs and search the closet for the accomplice and in plain view find cocaine, right? Because the accomplice could be in the closet. Now, if you're looking for a bazooka, you can't search a small tin. That wouldn't make any sense. Double jeopardy does not apply when there are new elements, such as the person later dying, giving rise to a manslaughter claim, right? So like if it was only robbery, but then they later died, you can come back and charge them for murder or manslaughter. Statute of limitations begins the day the cause of action accrues, death for manslaughter, and is for when the charges can be brought. That's the statute of limitations from when the cause of action accrues and when the date of death for manslaughter. So use substantial step for attempt. The model penal code will use unilateral conspiracy, and common law will use bilateral conspiracy. Ooh, we're getting down to the final subjects. Insanity defense is not a constitutional right. Insanity is an affirmative defense. The burden may be shifted or lowered. You can be tried for the same crime in different states without violating double jeopardy. For instance, if you kidnap and transport, asportation from state A to state B, you can be tried in both states. That's the third time we said that. One rule that does apply at grand jury proceedings is a rule of privilege. For instance, attorney-client privilege. And elements of a crime must be proved beyond a reasonable doubt by the jury. Amazing. Let me turn back into a human. So that's all the subjects, and now all we have to do is go through the all subjects super final review. And I told you at the beginning of class today, when you get to the end of something, most of you are going to be super fatigued, super tired, especially cigarette smokers. You're going to be cheaping, or what's it called, fiending for that cigarette. I know I tutor a lot of cigarette jewel smokers or whatever you guys smoke these days. What do you guys smoke these days? Jewels? No, not anymore. I don't know what's the cool thing. They're like, whatever it is y'all smoke these days. I know you're going to be really wanting to smoke them during the test. You got to overcome that and just be like, all right, we're locked in. It's the final stretch. This is when most people want to smoke their little magical smoking device and they want to go home and have a beer and they're tired and they just want to be done. And you start talking to yourself crazy. you're like, whatever, man. Like, I don't even care anymore. Like, whatever, dude. Like, just like, no, you studied hard as shit for this. You do care. Do not let yourself get fatigued and become weak. That's the true word. Most people die within a mile of being safe. So I have one more section to do. It's the total review. And honestly, it's probably the most important section. It's the total review. So I'm going to do it with vigor, and it's going to be solid. And I think that's how I want you all to end your exams. Let the last session be your best session. But before I do that, let me venture into this chat room, see what in the universe you are talking about. All right, so you guys are pretty good on guessing the animals. You guys are all taking Perkins. You guys are voting for me for president in 2028. I correctly predicted all the MBE predictions. No, they're not banned from YouTube. They're just I can't promote them, but I don't really like promoting on YouTube. It taught me so much about inflation and seeing people's like numbers and views. Like, okay, if you pay $200, you're gonna get tons of views. Like, that's not fair. I like seeing that like 628 people actually watch my video right before the bar instead of like 10,000 fucking robots, So I'm not worried. You can say political things, Rob. Don't worry. So Forrest Gump mechanically has a 75 IQ. Yeah, for sure. That makes a lot of sense. He was right on the cusp, but he was he was pretty fast, man. Me and him are like the same in football, nobody can catch us. If you know you're taking someone home after robbery, for instance, you can be charged an accessory. Yeah, if you're the getaway car, for sure. If you knew, the getaway car is definitely an accessory. Clarifying it because that's the key takeaway. Don't get a question wrong on death row like I did with 89% accuracy because of a moronic slip up, like missing the if you knew part, right? Like, yeah, if you knew. I mean, and something should give you rise to know. And like this question kind of bothered me the first time I saw it, which is like, Susie comes out of the bank, she got a big old stack of cash, and alarms are ringing, and she jumps in my car and says, "Take me home." Am I an accomplice? They're saying yes because you should have known. Like the facts indicate you're an accomplice. Me, I'm so like, what? You have a big bag of cash? Like I didn't know. I was just giving you a ride home, but it sounds like according to the MBE, you're going down as an accomplice in that scenario because you definitely knew the big bag of cash. Rob said life is like a box of condoms. Yeah, finish the sentence. What's the finish to that? OJ Simpson had a lot of supporters cheering him on during his car chase. Oh, definitely, dude. I was alive during that. I was only 5, but that was like a huge thing that everyone always talked about was the Ford Bronco, and everyone was cheering him on because they didn't know, they didn't know the facts yet, and he had a really successful career with the Bills. Like, there's a lot of factors. He's actually supposed to be a Philadelphia Eagle. That's a whole different story, but we'll talk about that. If he would have gone to Philly, we probably could have changed him, turned him into a good Samaritan. All right, so students can always fake a life. Wait, we didn't finish this. Life is like a box of condoms. You never know what you're gonna get. That doesn't make any sense. I went to Wissahickon High School in Philadelphia, or outside the city. That's called the suburbs. And we were the Trojans, and our motto was, "We don't break under pressure." But don't know if that's funny or not. So students can always fake a laugh, even for ridiculous bar facts. Solicitation, conspiracy, attempt, forgery, assault, larceny, embezzlement, first-degree murder, robbery, burglary, and false pretenses or fraud. Or you can remember that I use fiat, first-degree murder, the inchoate crimes, assault, theft crimes. Nice. Words alone are not enough for voluntary manslaughter, right? Like you can't be you ugly, stinky, smelly, and then pow. That wouldn't be enough. For voluntary manslaughter for criminal recklessness, I think of Conrad Murray, horrible I know, the doctor that killed MJ. Yeah, he was also liable for wrongful death. I remember it was 2009. I was working at summer camp. It was the summer of swine because all the kids at my summer camp got the swine flu, and they had to get quarantined. That was bad. That was good. It was the best of times, it was the worst of times, let's say. But that was also when Michael Jackson died, and we had to like explain to our little campers like who the fuck Michael Jackson was. And those kids are probably now old now. Funny how time goes. All right, so fire extinguishers definitely winning. All right, you guys are really getting to this fight. Okay, embezzlement. Yeah, Hannah, you got it. Embezzlement. Erica is saying me with 3 E's. Here is my final thoughts document I made during my Zoom review for anyone who wants it. 20 points. All right, final thoughts. We like that. Erica's from Brooklyn. I'm from Brooklyn. Pepper spray. Lauren, you definitely have pepper spray. Yeah, you seem like a pepper sprayer. You can't fly with it if you're flying. Yeah, it's definitely active terrorism. Rob's got the Sig Sauer. All right. Doesn't surprise me in the slightest. Elizabeth, just in case you're not flying with it, but you have it. Oh, you guys are talking about pepper spray. Be safe. I do not envy people doing the Miami to Tampa drive. That's me. I don't mind it, man. I like driving. I got my dogs with me. We're gonna listen to some good music. I don't know. I remember when I drove to Tampa when I drove to Tampa in 2017, the first time I took a bar exam, I did what I do now for a living. I went on my, like, I think it was when Instagram first came out or when I first joined it. I was super late to Instagram. I was super late to social media. I hated social media. Now I fucking post all day. Life sucks, then you die. But I remember I was on Instagram story and I went on my story and like maybe like 7 people joined. I had no friends, still the case. And I was like, hey guys, nice to meet you. My name's Andrew. I'm driving from Miami to Tampa. Let me tell you everything I know about the Florida bar. I swear to God. And then I just started fucking talking my ass off and going over every single thing for that 4.5 hour drive. And then I don't know if people joined or signed out. Maybe like my mom stayed in or something. I don't think she had Instagram, but that's what I did. I really think it helps to talk things out and flesh things out. And look at me, I turned a whole career into it. I mean, I teach for the Series 7, the LSAT, the GMAT, the GRE, and other things. I'm not a one-trick pony or anything, but that's what I did do. Okay, so let's see what Safwan's saying. My guy Safwan, we have a session today. We got to hash things out. You left some feedback that I appreciate and we want to talk about. So person A steals something, tosses it to person B. B is surprised and B keeps it. B is now guilty of larceny. Does B need to have known it was stolen? Yes, for possession of stolen property, you do need to know it was stolen. So y'all's Florida people should have chartered a driver together. No, I'm going to drive by myself and the piece is going to be so glorious. You can look into a drawer if you're looking for an accomplice and find something. You can't look into a drawer if you're looking for an accomplice and find. That's what I was saying about the bazooka. You can't look for the bazooka in the tin. So the Supreme Court of the United States ruled in Collar v. Texas that states have the discretion to define the relationship between mental illness and criminal culpability, and the Constitution does not require states to use a specific definition of insanity. That's Gozak, Mr. UFC himself. Rob just literally said the word crack with no context, and then Emily said beat me. Oh no, crack with no context, and then Elizabeth said beat me to it. What are you guys talking about?
You're
You
talking
said,
about
what are we smoking these days?
Wait, what? Wait, what?
You asked what we were smoking these days.
Oh, you are both smoking crack. Yeah,
only in the morning.
it's the best time. I mean, because if you smoke it at night, you're not gonna be able to sleep. So at least you're sticking to a calculated regimen.
So I'm strict on that.
Gotta be strict on that. All right, so we got 2 crack smokers in the building. Burden is usually on prosecution, but it's on defendant for self-defenses. Never thought I would say that to my bar prep class. We got 2 crack smokers in the building. So burden is usually on prosecution, but it's on defendant for self-defense. Yeah, that makes sense. Right, the prosecution has to prove it was beyond the shadow of reasonable doubt. Right, if you don't know your rights about probable cause, you can just listen to 99 Problems by Jay-Z. He pretty much explains everything. So wait, but getaway car charged for felony murder that occurred inside, if they aided and abetted as an accomplice, I mean, you would probably be accessory after the fact as a getaway car, not an accomplice. Elizabeth, you got swine flu that summer. Same, Erica. I don't want to admit this, but like I wasn't feeling really good, but I started hearing about what went down in that little quarantine. And I know that after the pandemic, I should have learned better. Like, I'm admitting this, but like I never got tested for it, but I might have had swine flu for sure, but they had it bad, these kids. If I did get it, I had a mild case. I was teaching roller hockey that summer. Me and my boy, Nate Larson. Good times. And now look, the Florida Panthers won the Stanley Cup. So I feel like I'm probably did that because a lot of my kids were from South Florida. The camp was up in Maine. They were kids from South Florida who played roller hockey. And one of their names was Matt Kachuk. No, I'm just kidding. I bet you those kids are smoking crack. No, I'm just kidding. I'm just kidding. They were good kids. They're doing excellent stuff. All right. So No Sleep Till Brooklyn by the Beastie Boys. All right, Erica, we get that. The drive down Alligator Alley does kind of suck, but in your free time, if you come back into the Everglades, you should do the Shark Valley like bicycle thing. You got these bicycles and you go up and down, and there's all these alligators that are like chomping, but not at you, just like they're just chilling. It's pretty cool. You can take pictures, you can like walk right up to them, put your head in. No, don't do that, but Don't say I tell you I did that. All right, and then about self-defense. The defendant has the burden of production, which means they must provide evidence that could support a jury finding of self-defense. And then two, once the defendant has provided evidence, the prosecution must disprove the reasonable defense claim beyond a reasonable doubt. Amazing. All right. Like I told you, the final stretch. And Rob, you were talking about your Sig Sauer. Look at my motto: guns down, books up. I don't need guns to defend myself. I don't need pepper spray. I am equipped with knowledge. All right, let's go.
Good luck.
Yeah, right. I know. No, but no, for sure. I might need one of those. I might need one of those things in the trunk if certain things happen. But for right now, I feel good. All right, so all subjects. A person can be convicted of both larceny and robbery, cannot be convicted of both larceny and robbery because a lesser crime of larceny merges into robbery. A person can be convicted of either but not both. We already did that one. Check it off our list. A person who takes a purse with the intent to steal it has committed larceny, even if moments later they decide not to take it and they haven't even left the store. It doesn't matter. Once you intend to take it, larceny has occurred. An agreement is enforceable if there's been formation and a subsequent recordation is not necessary, and lack of one does not preclude enforcement. Once you have the offer acceptance consideration, the contract has been formed. Any recordation of it subsequently is irrelevant to the discussion of whether there's been proper formation. Laxatives are not poison, and intending to cause someone mere discomfort is not intending to cause great bodily harm sufficient to constitute murder. I always tell the story of this kid who put Viagra in this other kid's drink when I was in high school, and then the kid got suspended. It's hilarious times. A product could be defective if there was an alternatively safer design. For example, if a car stalls but could have been designed not to, this could be a design defect, right? Design defect. In determining the burden of ESI, electronically stored information, the judge should consider the likely benefit of the material to the respective case, the needs of the case, the amount of controversy, the parties' respective resources, and the importance of discovery and resolving the issues. These are going to be when we should determine the burden of ESI. A case is not removable to federal court just because the defense has a federal question. The federal question must be raised in the complaint, or there must be diversity. Furthermore, just because a plaintiff could have raised a claim under federal law is not important. The issue is what claim was actually brought. They test that a lot. The federal question needs to be brought in the claim, not the defense. A motion for relief from judgment from newly discovered evidence that could not have been discovered earlier can be brought up to 1 year from the verdict. It is considered new evidence if the attorney overhears that the jury was biased and voted based on disdain for the lawyer and the teacher, because this would be considered juror misconduct. Remember, motion for relief from judgment up to 1 year for newly discovered evidence. If it's like a clerical error, it could be anytime. Laws targeting low-income housing are subject to rational basis, and the plaintiff has the burden of proof to show the law is not rationally related to a reasonable or legitimate government interest. Strict scrutiny is narrowly tailored to a compelling government interest. The burden is on the government. For example, an ordinance allowing picketing for one subject but banning picketing for all other subjects is content-based and subject to strict scrutiny. The president must spend money as appropriated. For example, if an appropriations act allocates money for wildflower planting, the president cannot spend money on training the troops and or retain the money in the treasury. Impermissible character evidence. Using 3 prior incidents of resisting arrest to show that someone likely conformed with that behavior in a civil case today is not allowable. That's impermissible character evidence. A state can enact legislation that would otherwise violate the Dormant Commerce Clause if the state is explicitly authorized by federal law or Congress. This is a correct answer. Look for that answer. If it's expressly authorized by Congress, it could violate the Dormant Commerce Clause, because, you know, it's like the principal saying, you know, the teachers are allowed to serve pizza in class today. Well, then the teachers can serve pizza in class. The principal expressly authorized it. Summary judgment is appropriate after discovery. JMOL is appropriate after the opposing party has presented evidence. Blasting is considered an abnormally dangerous activity that triggers strict scrutiny and is thereby a non-delegable duty. The court may order a man to walk to see if he has a limp without violating any constitutional rights. On the MBE, assume pure comparative negligence. Any plaintiff harmed can recover even if they're 99% at fault and join several liability. The plaintiff can recover the entire amount minus his or her fault from any defendant. If the jurisdiction is a pure comparative fault and has abolished joint several liability, the plaintiff can only recover the percentage each defendant is at fault individually. So you assume joint several liability, you assume pure comparative negligence, but If they tell you it's contributory, then you can't recover if you're at fault at all. If they tell you it's modified, you can't recover if you're over 50%. If they tell you it's common law rules, that would be contributory negligence, and that would also mean that assumption of risk is a complete bar to recovery. If they say they've abolished joint and several liability, that means you can only recover from each person individually. You really have to read the facts and answer the question if that's not clear. If a defendant is found guilty of second-degree murder in a trial where they're also accused of first-degree murder, they are implicitly acquitted of the greater first-degree, they're implicitly acquitted of the greater first-degree murder charge and cannot be retried for it, right? Like, if you're acquitted of first-degree murder, or even if you're found guilty of first-degree murder, then you're implicitly found not guilty of second-degree murder, because like you can't be retried for a lesser crime that you've already been convicted of the higher crime in the same proceeding. Evidence of photographs of a crime scene that would help an expert are likely admissible because they're relevant, and the photographs just need to be authenticated by someone who says that is what it purports to be. Now, in 2024, I feel like this law needs to be amended a little bit, because I've seen some of the photoshopping and catfishing, let's call it. I have this LSAT student, and she has a friend, and she was telling me like how much different her friend looks on the internet and in person. I'm like, yeah, well, that's because Photoshop is real, but at law, we still assume that a photo is admissible so long as it is authenticated by someone who can say that it is what it purports to be. A judge may impose sanctions on an associate if he comes to pretrial conference substantially unprepared and is squirming, for example. We could definitely impose sanctions on them, and maybe even on the supervisor if they let them come in a squirmy condition. A renewed JMOL may only be made if the JMOL was initially raised. And hey, what's up, Daniela? As you know, I'm going over. I had a 2-hour session before this, have this session, and then more sessions after, but such is life. This will help you. You're taking this test. So you should have been here from the beginning, but you've been my favorite student for a long time, so I'm not mad. All right, no offense to all my other favorite students. I have a lot of favorite students. I'm a lover, not a fighter, but I do like to fight too. So Semtech, under federal application, courts, I don't know why I cracked myself up. Semtech, under federal application, courts should apply the preclusionary effect of the court where the first case was decided, which may have been a state or federal court. So if it was a state court decision and now they're trying to refile, the question of whether non-mutual issue preclusion is allowed depends on whether the first court state would allow it or not. So this is the federal application. This is a Semtech case. This is a tough concept, but preclusion is procedural. It's federal. But Semtech states that under that application, courts are going to apply the preclusionary effect of the first court where it was tried to see if like it would have preclusion in the next court. So just look to see if it's preclusion, apply the preclusionary effect of the first court and where we filed. So rap, and I told everyone like 5 times now, if you look at my Instagram story, I put up all the rap albums. There were some country albums. There was a Taylor Swift album. There was some good stuff. I was pleased. I still have the best rap album of all time, though. Ill-Gotten Gains Restitution to this day. So what's rap? No interest in land is valid unless it must vest, if at all, within 21 years of the death of a life and being at the time that interest was created. So if a conveyance is to Tommy for life and then to Tommy's children, but Tommy doesn't have any children at the time of the conveyance, then this does not violate rap. And remember this from our one session, because it is certain to either vest or not vest. Either there will be kids or there will not be kids. So rule against perpetuities. What are things that violate the rule against perpetuities? Rights of first refusal. Like if you have a conveyance to Tommy, but Tommy, if you're ever going to sell it, then me or my heirs get a chance to buy it first. That would violate the rule against perpetuities. Be very wary to pick rule against perpetuities. It's not going to be the correct answer to more than like 3 at most questions. Probably will be the correct answer to 1 at most, if 2, but like, you know, it's not going to be a test covered with rap answers. A unilateral contract can be accepted by performance, and once performance has begun, the contract has been accepted, such as beginning the work for a legal agreement or waiting in line to, like, you know, anyone who waits in line can get the reward. An officer may be given a transcript to refresh their recollection. This does not require the transcript to be admitted in the best evidence rule. As my professor, Mike Graham, said, and probably everyone said since the dawn of time, even a bowl of spaghetti can be used to refresh someone's recollection on the stand. Anything can be used. Parole evidence will not allow admission of evidence to contract written terms. For example, if a contract is for 1,100 or 110,000, the parties agreed, we will not allow oral evidence that was for 100,000, right? Parole evidence will be allowed to show defect in formation, to show condition to contract, to show clarify ambiguous terms or trade usage or custom, or to show an additional term, but it's not going to be allowable to show a contradiction. I really like the question with the horses where it's like gray horses with, and then we're going to bring in evidence that it was supposed to be black horses. No, we can't bring in evidence that was supposed to be gray or black horses. When we pick an animal, we have to really just pick one and stick to it. Like that's the most important thing. And then the other thing is that they had a part that said, and it comes with a saddle. Well, that's additional. So we can bring in the oral evidence that it comes with the saddle, but we can't bring in the oral evidence that it was a black horse and not a gray horse, if that makes sense. And obviously you can tell I'm a purple cow now. Purple cow now. Okay. Personal jurisdiction can be accomplished via minimum contacts and is proper to submit affidavits to show lack of PJ. Sure. Venue is appropriate where the cause of action accrues and where any of the defendants reside. Just because there's another proper venue does not mean that it must be brought there. It just needs to be brought where there is a proper venue. Arson requires malice, which is less than specific intent, but more than mere negligence. For example, if a guy sees a flame going towards a house and could stop it, but decides not to because he wants the house to burn, this is arson. We talked about this. So for all the realtors out there, and you know, in Florida, at least, if you are licensed to practice law, you can become a realtor without having to take the realtor's exam. So maybe selling houses would be a cool thing to do. Exclusive right to sell, the broker must procure buyer for commission. Exclusive right to list means that you have the right to list, but if someone buys the property on a different listing or, you know, without your, not from your listing, then you're not going to get commission. Exclusive right to sell means that no matter what, you're going to get the commission the property sells. And then a non-exclusive right to list or sell just means like, you know, you don't have exclusive rights. So ready, willing, and able buyer must be at the asking price, not $1,000 short. So if they ask for $500,000 and the broker or the realtor comes up with, you know, $499,000, that's not going to be a ready, willing, and able buyer because it was indeed a little bit short. So I'm going to steal Samaris's. Samaris is a Florida student, so she's not even here. But this was her character yesterday. We were bouncing back and forth as animals. And then I'll come back to a human to finish the job. All right. So Erie applies to diversity cases, not federal questions. We've kind of enforced that today. In an Erie case, privileges are a substantive issue. In a federal case, we apply federal procedural and state substantive law. Oh, in a federal question case, I'm sorry, my bad. In a federal question case, we're going to apply federal procedural and federal substantive law because it's a federal question case. We're only going to apply state substantive law for diversity cases. There's no federal common law recognition of physician-patient privilege, right? That's not a federal privilege. This one, a lot of people get wrong. A lost volume sale is likely not operating at full capacity and has inventory. Therefore, a breach of non-acceptance would not give rise to damages for the whole contract price, but just the lost profits, the sales profits, which could either be measured by the difference between the contract price and the market price, the difference between the contract price and the resale price, or the anticipated profit on the original sale, not the actual price of the computer, let's say. Like me, I sell digital materials. Let's say I sell my QBank, right? And let's say we have an agreement to buy the QBank and they don't end up buying it. Is the damages for the entire QBank or are the damages for the lost profits? It's you know, a question, because if you're not operating at full capacity and have inventory, then it wouldn't be the entirety of it. But if you are operating at full capacity and you have no inventory, then it wouldn't be. For me, that's a lost sale, right? Because I'm at full capacity. But for a boat dealer who's got like tons of boats on deck, you know, then that would just be a lost profit sale. So it's kind of a fact-specific question. All right, race hips or low quitter. If someone's hit by a flower pot from a balcony, they have to show which balcony it was. They cannot sue all the balcony owners for joint and several liability. Right? if someone's hit by a flower pot, they have to show which balcony it was. They can't just sue the landlord, or they can't just sue all balcony owners. Party opponent admission is not applicable if it's a former employee statement. We said that 5 times today. Prior testimony is not admissible against a defendant if the defendant was not a party at the previous case and did not have a chance to develop the testimony by direct or cross-exam. Earnest money is not necessary for a land sale contract, as the regular rules of consideration will apply. A motion to strike should be filed before a reply if the defense included irrelevant material. In a race notice jurisdiction, if there are 2 parties and neither BFPs, the first to record will prevail, because it's race, first to record, and notice, but neither BFP, so just gonna be first to record. If one of them would have if one of them was a BFP, they would have had, rights. The rule that a psychiatrist cannot pontificate upon the mens rea element of a crime applies in criminal cases, not civil cases. So Daniela, I know you clarified that in my boot camp, and I should have been on top of that too, because it's in my program guide. Federal common law applies for claim preclusion, issue preclusion. Like I said, it is federal, but under Semtech, the preclusionary effect will look at where the state, the first court was a state, federal, whatever, the first court. As far as the preclusionary effect of involuntary dismissals, federal courts will adhere to whatever the effect the involuntary dismissal would have in the state court in which it was sitting. Statements made by the declarant that serve as circumstantial evidence of the declarant's state of mind are not hearsay. For instance, we can allow a defendant to testify that he didn't hire a woman because of her abilities, not her age, in an age discrimination lawsuit. Mere allegations will not support a motion for summary judgment. You should consider a motion for more time for discovery to determine essential facts. I like that answer when you see it. They need more time for discovery to determine essential facts. That's a strong answer choice when you see it. A criminal statute can establish a duty of care for negligence per se. For example, a statute requiring a sprinkler system. And if you fail to have a sprinkler system, you can be liable for negligence per se. One of the questions my student this morning, whose name rhymes with America, I helped her with, was the one about there's a negligence per se, you go over a median, that's a violation, but then they put in uncontroverted evidence that the other party puts in uncontroverted evidence that they had a heart attack. Well, because the retort, the response was uncontradicted, right? You were having a heart attack. You didn't violate any duty, even though there was a standard of care set up by a statute. If you have rebuttal evidence that's uncontradicted of you having a heart attack, then there's no way you could have foreseen it, and you actually will get summary judgment because you had a heart attack, and even though you violated the statute, you couldn't have foreseen it. So that's just a kind of little nuance. That's a tough question that Miss America did this morning.
So that means no damages are awarded to the plaintiff?
Again, a different question, right? About whether damages are awarded, but you wouldn't be liable for negligence or negligence per se. I mean, I can't say whether or not, yes, the correct answer is that no damages are awarded and the other person is pretty much screwed. But in this insurance world we live in, I'm sure that you would get compensated somehow, but the person would not be liable for negligence is the answer to that question. Whether or not they would pay damages is more of an insurance question, I guess. But yeah, good question. All right, you do not have a duty to protect your neighbors from sunlight. So there's no claim of action if you tear down shade. Me and my neighbors have that going on with like our trees, and then when they cut their trees, it's more sunny. I like it more sunny so my plants can thrive, but some people like it more shady. The standard for relevancy is whether the evidence has any tendency to make a fact of consequence more or less probable. So right, any tendency, it doesn't have to prove it. It just has to be like, oh, well, that would be, that could help them sway them one way or the other. Attempted murder is a specific intent crime. Therefore, playing chicken with a car to scare someone is not sufficient. You have to actually have intended to murder them. Even if you slip on the brake, it's not going to be attempted murder. It could be murder, maybe it was depraved heart, but it's not going to be attempted murder because attempt is specific intent. You cannot sentence a juvenile to life without parole who's convicted of a non-homicide offense. Newspapers are self-authenticating. A regulatory taking occurs when the owner has been deprived of their investment-backed expectations and deprived of the economic viability of the land, right, as opposed to a possessory taking. So a regulatory taking would be like, you grow corn and then they make a law that you're not allowed to grow any corn in the county, that would be a regulatory taking under the Penn Central multi-factor balancing test. If a party breaches a contract, the other party must mitigate losses for sure. So like if you are supposed to be a teacher and then you're gonna get paid 45,000 and then they don't give you the job, and then there's another job available as a teacher for 45,000, you actually have no damages because you had a duty to mitigate. Now, if the other job is as a secretary, then your damages are 45,000, you didn't have to take it. If the other job is a teacher and it's for 40,000, your damages are 5,000, whether you take it or not, because you had a duty to mitigate. Anti-commandeering. So the Congress cannot force states to enact laws about drugs in school zones. So remember, they can induce them through conditional funding. Like if you don't make these laws, then we're not going to give you if you don't make these laws, then we're not going to give you funding. They're allowed to do that, but they can't force them to make the laws. That would be commandeering. Liability insurance is admissible to show ownership or responsibility, like for a plane. Subsequent remedial measures are admissible for ownership or control as well, like painting the fence or showing a alternative design was possible. A product's liability case can rise due to failure. Can someone mute your thing? Sorry. Hello. Oh, you're good. Okay. A product's liability case can arise due to a failure to warn, for example, not warning properly the need to put special tires in order to drive a car much faster than the speed limit, right? Like if you say, hey, this is a car, and everyone knows the speed limit is 85, but if it goes any faster than 85, you need different tires. Well, you have to put down the warning label because people are driving 95 all the time, and that's a foreseeable misuse. Issue preclusion is narrow, actually litigated, essential to judgment, not a general ruling, a specific ruling, right? Like they actually litigate it. Claim preclusion is broad, it has to be the same parties, same claim. Non-mutual issue preclusion means at least one party is the same. Mutual issue preclusion means both parties are the same. Defensive issue preclusion is used by the defendant. Offensive issue preclusion is used by the plaintiff. One other concept is the claims, if the defendant prevails in the initial proceeding, then the claim is subsequently barred. If the plaintiff prevails in the initial proceeding, then the claim is subsequently merged. Some good vocab words. Co-conspirators are liable for foreseeable crimes and furtherance of the plan. It is too late to withdraw or abandon if you are already dropped the robber off at the bank. Felony murder killing occurs during the commission of a crime. A co-felon cannot be sentenced to death if he or she wasn't the killer, intending to kill, or at least a major participant in the crime. That's the majority rule. There's a federal right to a jury trial for matters at law, for legal or monetary damages, or for certain actions that were available at law before the Constitution, writs of ejectment, or Safwan taught us, writs of replevin. Battery is a dignity tort. So an offensive touching is all that is required. Sending someone a rat poison cake amounts to battery, and there's no need for a foreseeability analysis. The offensive touching does not need to be personal. It can be sending the rat poison cake or pulling away the chair. So it's a dignity tort, meaning there doesn't have to be damages. A lot of people get this one wrong. You do need damages for like misrepresentation or interference, right? So if I misrepresent something to you and I sell you this, and my favorite juice right now, this sea moss juice, and you buy it for $30, but it was really not that good, but then you sell it to your friend for $30, you didn't suffer any damages, no pecuniary loss. Therefore, there's you won't be successful in your claim because misrepresentation, interference, those types of claims do require pecuniary loss. Battery is a dignity tort. You don't need to show any damages. If you punch me, like if Chris Rock slaps the shit out of Will Smith and Will Smith got that Philly boy inside him, just eats it and feels no pain, maybe what he did after was kind of weak, but like in that moment, it didn't really hurt him, but it was still battery because it definitely hurt his dignity. Like he made that clear. So, oh wait, it was the other way around. Shit, Will Smith slapped Chris Rock. So Chris Rock is the one who was hurt. Well, hit, but it didn't hurt him. Yeah, he just kept going. So yeah, it didn't hurt him at all. Will Smith was the one who had his dignity offended by the joke. Okay, so whatever, not the best example, but we understand. I can't believe I confused who hit who. I just figured the guy from Philly would be the tough guy who got hit, but it also makes sense that the guy from Philly is the one who reacted very quickly with violence. Okay, so routine business practice are admissible. For example, a person can testify about the habits of the mailroom people collecting the mail, right? Because he has personal knowledge, and it's a routine business practice. A police officer may reasonably rely on a defective warrant, but may not rely on information he knows to be false. The good faith exception, he may rely on a defective warrant. If a contractor does work but doesn't pay the licensing fee, that's merely to raise revenue. The homeowner cannot refuse to pay the contractor as a loophole because the purpose of the licensing fee is not to protect homeowners, right? So look for that you have a contractor or an insurance company or someone who's trying to get out of a contract because they didn't follow the statute, but it's, you know, not related to the contract. That's going to be a public policy exclusion. Concurrent tortfeasors are jointly and severally liable for the damage they cause. For instance, the two companies pour chemicals into the water. We can also look at the market share liability theory. Like if three companies make a defective fungible good, fungible meaning they're all the same. Three companies make one pill, and you know Rob's in this business, the pharmaceuticals. So Rob, Tom, and Johnny all make this fungible pharmaceutical pill, and then it causes injury. Well, if Rob produces 50%, Tom 25, and John 25, then Rob could be 50% liable, Tom 25, and John 25, based on the market share liability theory. Deposition must contain description of matters of examination. If a vague depo is served on corporation and requires president with no information of matters for examination, and president says she has no personal knowledge of matter, she may seek a protective order against the deposition on the basis the device being used is to harass her. Once a deed is transferred, ownership has ceased for the grantor. Transfer occurs when there's intent for the deed to leave the control and dominion with no exceptions. So if you deliver something and say, hey, give this back to me if I ask, that's not delivery. No directed verdict if reasonable jury could decide either way. For instance, expert attests to a jar shattering that seems to be a defect. The jury could decide either way. The Sixth Amendment is for criminal cases, the confrontation clause and speedy trial and right to counsel after adversarial proceedings have begun. The Seventh Amendment is civil, applies to federal only. That's your right to a jury in certain cases at law. States can enact legislation to guarantee jury trials in certain cases, and if it's a state case, then apply this law. So be careful if they say plaintiffs can request a jury or defendants can request a jury, and then they switch it on you. Again, be very careful. A lot of people, most people, unfortunately, either just fail or just pass. So if you want to be on the right side of history when it comes to that, try to read carefully and catch yourself getting some of these really detailed questions that just hinge on one word and be like, ah, shit, I caught that. Go me, 137, right? Be on the side of detail. My grandfather was very into detail orientation. Just take care of the details and everything else will take care of itself. That's what he used to say. If both parties are mistaken, reformation is a proper remedy. That makes sense. Parole evidence does not exclude admission of mistake or any defect information or condition to contract or to clarify ambiguous terms or to add additional terms, just not to conflict a fully integrated contract. Article 3 requires either federal question or diversity, and Congress cannot legislate to circumvent the diversity requirement. Am I a human or not? Okay, I'm a human. Okay. If the bridge is complete and you are suing for injunctive relief, the case is now moot and you cannot sue. So when you see that one, it says, oh, the case is now moot or the case is not ripe. I like that answer choice and see if it aligns with the question. If it does, and you're like, oh, this is a moot situation, then, that's the right answer. I'm not saying it's always the right answer, but it's a good answer to pick if you could see it. Speaking of picking, I think this is the last thing I can be is a grizzly bear. Let's go. Have I been the grizzly bear before? This is my first time. I think this is my first time as a grizzly bear. So my name is now Yogi. Once you have probable cause, you don't need a warrant, and people rushing around, throwing things out amounts to exigent circumstances, right? The cop hears the people flushing the toilet. Where are they flushing? The same crack that Rob was smoking, and that would be reason for busting in on them. That's how you smoke crack? I don't think that's how you smoke crack, dude. You're not a crack smoker. I was gonna say, you're clearly not a crack smoker.
You caught me. You caught me.
I am just giving myself away. No, I'm just kidding. All right, but that's not how you smoke crack. I'll teach you. That'll be our next, after we pass the bar. Yeah, there you go. That's more crack like. Okay. So what are we talking about? Okay, once you it's okay to have barbed wire that's apparent around property that people intrude to hunt. Yeah, it's definitely okay to have barbed wire, and if they trespass and injure themselves, they're idiots and you're not liable. You're allowed to have barbed wire around your property to protect from hunting. See, I'm a bear. Of course I want people to not hunt me. The best objection to failure to object is that the party's substantial rights were plainly affected. I love that answer when you see it. This was a plain error that affected their substantial rights. That's why we want a retrial. Even if they didn't object when they were supposed to. If that's the case, we are going to allow for a retrial. You can't impeach a witness based on collateral matters if they get some small detail wrong. If a law is general and not targeting religion, it is applicable. So, like, the example that we give is the law that was targeting Santeria in Miami and sacrificing goats was struck down because it was targeting the Santeros. The law in Arizona that banned peyote, they said was general and uniform and wasn't targeting the natives in Arizona. So that's kind of a Supreme Court distinction of that. Federal agencies must spend monies as directed by Congress. If you repudiate a contract and the other parties reasonably rely on their repudiation and makes a separate deal, it's too late to cancel the repudiation. So finally, evidence is relevant if it has any tendency to make a fact more or less probable. That's a really obvious, we should all know this, and we totally reinforced it. Again, this is, probably the most comprehensive master cram guide on earth, and it's not comprehensive entirely. There's things on here things that we tested that are not on here, but I promise you this, if you master this cram guide, you cannot fail. You will have one of the highest scores in the state. And I can tell you that because I've studied this way, by creating cram guides, by mastering them, and by having some of the highest scores in the state. So I really believe that we're all over prepared. It's been such an absolute pleasure. I'm gonna go over the chat, but before I do, there's just two things that I wanted to share in the chat. One, obviously, of course, if anyone doesn't have access to this master cram guide, I'm putting it in the chat right now so that you do have access to the master cram guide. And then the other thing, I would definitely be remiss if I didn't put this in the chat, is going to be, shoot. Here we go. Is going to be this form. Just a simple feedback form about my classes. If you've been to any of the classes, the boot camps, the essentials course, the MBE course, the Florida course, if you did one-on-one tutoring with me or any of my tutors, and just the more feedback, the better, because we want to continue improving. And like I said, one thing that I would love to hear positive feedback about are my customer service representatives like Alexis and Sam and Ali and James and Jesse. We've all been working really hard to put you in position to pass. And I can say with 100% honesty and integrity that I've never felt like my students were more prepared. We've been doing this for many, many years, 7 years, in fact, and we've been getting better. This master cram guide is the product of 3 administrations compiled on top of each other. I really think that every one of you should pass. And if you feel that that's not the case, you still have some time to hit the books and to dot your I's and cross your T's. So again, let me just check the group chat and see what's going on here while you guys fill out those forms. All right. Hi, Daniela. Don't worry, we're about to start. You slept in. Whoops, don't worry. Class never starts. Oh, you're saying for our session. Well, our session will start in 2 minutes. Yeah, go do that today and not on Tuesday. It won't be covered in rap. It will be covered in hip hop answers. Yeah, I know a little bit about hip hop. Correct in that situation. I know about rock and roll too, jazz. I know about music. SCOTUS ruled in Graham versus Florida that juveniles cannot be sentenced to life in prison without parole for non-homicide cases. Thank you, Zach. Sentencing a juvenile defendant who did not commit homicide to life imprisonment without the possibility of parole violates the 8th Amendment because it disproportions the crime. I think I had one where travel expenses were not included in the calculation of the teacher. So legal fees were not included. Legal fees are not incidental. If you need to find a lawyer to see if a contract is enforceable, that's not going to be included incidental. But I think the travel fees would be included. Yep. It's that answer. Okay, yeah, the 200 was included. Ramel just trying to confuse the class. Don't worry, we're not confused. Thank you, Andrew. Good luck. Find me on IG, Eliza Thornberry. Oh, I love Eliza Thornberry, one of my favorite characters, and Nigel, her father. You guys can add me on Instagram too. Andrew Dennis 13, pretty easy. 13 for my guy Dan Marino. All right, that seems to be it. So thank you so much, Erica. It's been an amazing run. What we just did 4.5 months together. We also just did 5 hours together, you and I, Erica. So it's been a lot of fun with all my students, but job's not finished, right? Like Kobe Bryant said, job's not finished. I want you all to lock in. And if you want to make me proud, it would be by continuing to study hard and taking care of business on test day. Thank you, Judy. Thank you, Sean. Thank you, Rob. All right, that about does it. I'm going to go ahead and stop this recording.